All right. Ms. Rivers, you ready? Let's go on the record, please. Whoop. There we go. In State versus Hodges, it is the 15th of August. We're already halfway through August. Monday, we are waiting on a couple jurors. We have our prosecutors here. We have our two defense attorneys. We have Mr. Hodges. Good morning, Mr. Hodges. What I thought we'd do while we're waiting on our last few jurors is start our charge conference. I'm going to mute two more. There we go. Sent to the lawyers yesterday, sort of midday, a draft of the charges. I'm going to share a screen so they are up and we can talk about them. And then Ms. Ocam later yesterday added 4 more that she'd like to see, and we can figure out if we're going to do those or not. The way I typically work through the jury charge is jump to the areas in the charge where I've got questions. If I skip over a paragraph, a sentence that you've got concerns about, let's go back to it after we talk about the question I had. And then I'll see if after we've gone through the document as edited, if there's anything the state wants added or subtracted. And what we're looking at on the screen does not have the 4 new requests, not because I don't think they're appropriate. It's just, this is what I did yesterday, and I didn't get back into this after I got those 4. I have the 4 patterns, and we can put them up on the screen if we need to figure out where we'd slot them in. And then I'll, of course, hear from the defense as well, if they think there are things that were excluded that should be added or things that are in that ought to be out. So I am going to jump all the way to statement of defendant. I'm not aware that Mr. Hodges gave any statements. I appreciate that. I think he may have said, I'm not going to run anymore on the audio of the arrest. That's about it. But I don't know what interactions he had with Detective Zimbrick. I don't think we've had a Jackson Deno or anything like that. But let me start with the state. Are there any statements of Mr. Hodges you're aware of that you seek to admit through what I think will be your last witness, Detective Zimbrick?
Yes, Judge, he made a statement, but when the state's not wanting to use that in our decision. Obviously, he specifies that it will
revisit that.
Yes.
Okay.
But as I state the case, we're not intending to say it.
And what was the setting in which Mr. Hodges gave his statement? Was it to Zimbrick or one of his colleagues? Okay. After Holland et al. Arrested Mr. Hodges and then took him down to homicide or wherever he went, soon thereafter, Detective Zimbrick interacted with him.
Yes.
Okay. But that's not a statement you intend to use.
Yes.
So for now, I propose that we don't include the many, many paragraphs that are appropriate if a statement of Mr. Hodges was introduced during trial. I'll put them back in if something changes, but right now it doesn't sound like anything Mr. Hodges said in a custodial setting in the form of an interview, as opposed to the spontaneous statement that Mr. Hodges made that I don't think is even audible to most, that he's not going to run anymore. Ms. Primovic, do you agree with my proposal that all these paragraphs, you can see on the screen, there's one that's highlighted, but the others that are struck through are all a continuation of that necessary language if the jurors heard a statement that your client gave while in custody to law enforcement?
I agree with you.
Okay. So I'm going to leave it as it looks right now. If Mr. Hodges doesn't testify, or if he testifies but you don't seek to admit the statement, then all those paragraphs come out. Okay. Next, on pages 13 and 14, I don't know that we need to instruct the jury on the intent to steal. It doesn't seem to be what this case is about. There has been unrebutted testimony that people were coming out of closets, coming out of the apartment with clothes, shoes. There's the camcorder strewn in the front yard. So this intent to steal charge typically applies when there was an entry but nothing got taken. But maybe they see the alleged perpetrator running away with an empty bag or left an empty backpack or something. So I don't think it's necessary. I think it's not going to confuse the jury, but I don't want the jurors to be working through, well, was there intent to steal or not? In fact, the word steal doesn't come up in the burglary charge. It's the intent to commit theft. But either way, I think it ought to be excluded. I'm assuming you asked for it, Ms. Ocom. Do you have any objection if I omit intent to steal?
No.
Okay. Similar, well, Ms. Primovic, any objection to that? The meaning of entry, it fits sometimes if all we know is maybe a suspect reached a hand in, but then an alarm went off or a dog barks and the person runs and the witness said, I saw him sort of maybe going through the doorway. Here, we've again got unrebutted testimony that there were at least 3, if not more, young men in Mr. Barry Buchanan's apartment. There's no question they were on the inside. And so I don't know that we need to define entry. Again, I don't think the facts of this case call for that. Do you agree with that, Ms. Ocom?
Yes.
Ms. Primovic?
Yes, sir.
All right, then those 2 I will remove. All right, those are the only questions I had before I got Ms. Ocom's 4 additional charges. We do have all our jurors now. So I think what we'll do is pause this discussion. When we come back, we'll talk about Ms. Ocom's 4 additional proposals, and then I'll see if there are any changes beyond those that the state wants, and then I'll see if there are any changes that the defense wants. Ms. Ocom, anything we need to discuss before we bring the jurors in?
No.
And as of now, you intend to call just one more witness, and that's Detective Zimbrick.
Yes.
Okay. Ms. Primovic, anything we need to talk about before the jurors come in?
No, you're.
Okay, let's bring them in, please.
All right, adjourn.
Thank you, Deputy Gordon. Happy Monday, everyone. You all can be seated. That was kind of flat, but I'm glad you're back, all 14 of you. I appreciate it. Hope you all had a good weekend that was devoid of discussion of the case of State versus Hodges. I had a nice weekend. I missed you all, but I knew I'd see you on Monday. I got a haircut. That was a big event for me. And I'm sure the lawyers enjoyed a little time away from this as well. We have, I believe, one more witness from the state, and then the state is likely to rest. Then we'll figure out what happens after that. Ms. Ocom, if you'd call your next witness, please.
Yes, Judge, the state calls Detective Brett Simbrick.
Brett Zimbrick, Zimbrick.
Good morning, Detective Simbrick.
Good morning.
I will need to speak up a little bit. I'm back and I can't hear you.
Correct.
Simbrick, would you please introduce yourself? What do you currently do?
I am retired.
Did you have to come here from somewhere to get to work today?
I did.
Where did you come from?
Northeast Tennessee,
You're retired from what?
the Atlanta Police Department,
And how long will you be in Atlanta Police Department?
33 years.
Can you tell me the years of the different years?
Pardon?
The years of your different years.
33 years.
Or when did you start and when did you finish?
1986 to 2019.
When you retired in 2019, what was your position in the Atlanta Police?
I officially retired in September of 2016 as a homicide investigator, and they had a program in place that they immediately rehired you to mentor and teach and do follow up on investigations in the same position. So I retired after 30 years as a homicide investigator and then stayed for 3 more as a homicide investigator, the entire time maintaining my state certification, post standards.
So how did you get involved with the murder of
The last 10 years or so of my homicide career, I was in the cold case complex squad, where we would review cold cases and we would handle the complex homicide investigations. In 2018, November of 2018, I was asked to review this case file as it was considered a cold case.
How does a case become a cold case?
The original detectives that are assigned the cases work all of the leads, follow up on everything that they possibly can, and they'll hold the case for as long as they think there's something to do on the case. Obviously, detectives continue to get cases, and at some point, their attention is diverted from cases onto the next case. And if developments or leads pop up, they pick up their old cases and run with them. Or if they're too busy, cold case would do it.
And when a case gets to cold case, you said it's cold case in complex cases,
Yes.
do you get assigned a cold case, or do you just pick out a file and decide what it works?
The supervisor of the squad would go through the files occasionally and pull cases randomly and ask people to look at them.
So when he's looking through the file, is there a reason he's looking through the file, or does he just randomly pick out a file and assign it to him?
Sometimes investigations would get a lead 10, 12 years later, and that phone call would come in, which would then trigger the investigation to be reviewed. I don't believe in this case that a call came in or any other lead had been established. It was just a random pick up and look at.
So your supervisor, what's your supervisor's name at the time?
Leanne Lacoste.
Is that a he or she?
She.
She tells you, does she tell you you're assigned to this case now?
She just asked me to review it.
And did you review it?
Yes.
Said in November of 2018.
Correct.
When you're reviewing a cold case, what do you do as part of your review?
You take the file and you read it from front to back, every page. If there's videos, you watch videos. If there's recordings, you listen to recordings. You just review the entire file to see if there's something that was missed, something that can be followed up on. Sometimes you contact witnesses to determine if they may have recalled something recently, or if they failed to tell us something at the very beginning and now they're more comfortable talking about it. Review physical evidence if there is physical evidence. Make sure that it is where it needs to be.
So you say you review and you talk to witnesses. Is it typical for witnesses to remember something that far after, or do you just talk to them again for your purposes?
You call them up, or if they're local, you go visit them. Some instances, time has the way of people becoming more comfortable with the situation and they'll remember more. Sometimes people don't like to talk to the police, but as they get older, they don't have the problems that they did when they were younger. Sometimes they hear things over the years, people talk and they pick up different things. So you just kind of feel them out to see if there's anything new that they can add to the case.
So it is not abnormal so when you talk to a witness after that there are more things that the witness remembers?
It's not abnormal. I mean, sometimes people remember things differently.
And so what did you do for the Malik Buchanan murder? What did you do in this case when you got it in?
Reviewed the case. There weren't many witnesses, just a couple of witnesses in this case. There was some physical evidence that technology obviously has advanced from the original date of this homicide. There was some ballistic evidence. I made contact with the ballistic lab to make sure that the evidence was where it was supposed to be. And there was some fingerprint evidence, and I contacted crime lab to make sure it was where it was supposed to be.
You said ballistic evidence. What do you mean by ballistic evidence?
Shell casing from a firearm.
So are you talking about the shell casing that's been admitted into evidence that was the ballistic evidence you're talking about?
Yes.
You said that there was, you checked to make sure the fingerprints were still there, correct?
Correct.
After you find out that the fingerprints evidence is still there, what do you do as it pertains to the fingerprints?
I make the inquiry as to whether or not it's on the APHIS system and if it can be checked and rechecked, I guess, make sure it's in the appropriate file where it should be if there is to be a match made.
And when you found that was in the appropriate file, what did you do?
Just followed up, continued to review the file until I made another inquiry in December of 2018 with the crime scene people and was advised that there was a match to the fingerprints that were recovered on the crime scene.
And that December of 2018, who was the person that advised you that there was a match?
Samuel McCook.
After you were advised that there was a match in December of 2018, what did you do next?
Once there was a match made with the fingerprint that identified a possible suspect in the case, then research is done on the possible suspect.
When you were doing research on the possible suspect, did you look for photos?
Yes.
And did you, so if that was 2018 and you knew that you were looking for present photos of the possible suspect, or do you look for younger photos of the suspect?
The research is done from the point of the crime that was being investigated. So the crime that of this particular homicide was in 2007. And so that's where the research began, from 2007, that general area going forward and going back based on the age.
I'm showing you what is being admitted already as states 39 photo lineup. Is that the photo lineup put together?
It is.
So you had a picture of you agreed to the suspect. What was the suspect's name? You agreed to the suspect in 2018.
Jerry Hodges.
So you had a photo of Jerry Hodges. How did you put together the photo lineup of the other 5 pictures?
The 5 additional pictures, we call them filler pictures. We have a database that is available to us on our desktops at the office. It's a computer program that you're able to input information into, asking for specific identifiers, and then the computer will then give you countless possible individuals for the criteria that you asked for. So you're asking for males, you're asking for African-American males, you give it a age range, 16 to 20, 17 to 50, whatever you put in there. You can ask for specific complexions, hairstyles, mustaches, facial hair, glasses, jewelry. There's countless parameters that you can ask for, or identifiers that you can ask for, and the computer will then generate and give back to you, sometimes hundreds, sometimes thousands of possibles. And then you go through those possibles, and based on your experience and knowledge of the case and the individual that you're looking at, you pick 5 fillers that are similar, that you're not looking for exact matches or identical twins, obviously, but similar characteristics of the individual that you have identified as a possible suspect. And then with those 6 pictures, you just randomly assign a number to them and shuffle them up, and that's your lineup.
And when you do this lineup, do you do a single picture a page, or do you put it on one page of 6 pictures?
In this case, it was 6 individual pictures, each of them in a separate folder.
And after you put this lineup together, did you attempt to locate the witnesses that you said you read the file from? You read all the file.
I was able to locate the witnesses that were identified in the file. I spoke to Kristen Canada and Corey Gooden.
When you located them, when did you locate them, in 2018?
It was 2018. I located them the end of 2018. Mr. Gooden was in Alabama and Miss Canada was in Illinois.
And after you located them, did you attempt to show Dr. Canada or Dr. Gooden the photo line?
I personally showed Mr. Gooden the photographic lineup. I met with him in Alabama, and the photograph that was presented to Miss Canada was FedExed up to Buffalo Grove, Illinois, where we had made contact with the detective division up there. That's where she was living at the time. So we sent the lineup to Detective Montiel in Buffalo Grove, and he made arrangements with Miss Canada to meet and present the lineup.
When you talked to, let's start with Corey Gooden first. When you talked to Corey Gooden, you said you met him up in Alabama.
Yes.
What conversation did you tell Mr. Gooden?
What I like to do when I meet with witnesses again in person is to have them go back over what they recall from the incident. I have a good idea at that time what he had originally told the detectives in 2007. I had his original statement, and it's more of a attempt just to get the individual to be comfortable with talking to me. It gets them mentally back to the place in 2007 when this crime happened, and kind of get them to relive it a little bit and then explain what they recall from the incident. Mr. Gooden was consistent with what he said to the detectives in 2007, and again with what he told me in 2018. So I was comfortable with him understanding why we were there, what we were going to do, what we were talking about. I read him the admonition form, and I presented him with a lineup. and Mr. Gooden took his time and then explained that he couldn't really make an identification based on his experience in 2007.
And then when it comes to Dr. Canada, you said you sent it to Buffalo Grove, Illinois Society of Ontario, correct?
Correct. I sent 6 pictures to Detective Montiel along with the admonition form. Detective Montiel had no idea who the suspect was in any of the pictures. He was just tasked with making contact with Miss Canada and arranging to show the lineup.
And why did you not tell Detective Montiel anything about who the suspect was?
You don't tell the detective because you don't want anybody to influence a decision or make any kind of suggestive comments about any of the pictures that are presented in the lineup. It's kind of a blind lineup at that point. If he doesn't know who the suspect is, then he can't suggest anything to her.
And when you sent the pictures, did you have names of suspects on it, or were they just numbers?
Just numbers.
And after you sent it to Illinois, did you get a call back from Illinois?
January of, a few days after the new year, January of 2018 or 2019, January 3rd, Detective Montiel called and said that he and Miss Canada had been able to coordinate a time. She had come in, he presented the lineup, and she had made an identification. He indicated it was photo number 3. He had her sign and he did the paperwork, and he would be FedExing the package back to Atlanta. And he did.
I see that you looked down and you looked at something in front of you. Those are your notes from when you investigated the case?
Supplemental report, yes.
After you get that confirmation, did you do a little bit more research on suspect Jerry Hodges?
Yes, I had done some research on Mr. Hodges.
You go back to 2007 to figure out where the defendant lived at the time.
I did. I just wanted to make sure that he didn't live at that apartment complex or previously had resided in the apartment complex or anything like that, and he had not. So.
And did you figure out where he had lived in 2007?
He lived in the 2400 block or 2500 block of Martin Luther King Drive with his mother.
With his mother?
Yes.
And did you figure out what his mother's name was?
Tammy.
Is that the same last name?
Yes.
And how far was the 2500 block of Martin Luther King from the incident location, 7500 Millway?
I'm going to say 3 or 4 miles probably.
Did you figure out if there was any mode of transportation between the 2500 block of Martin Luther King and Millway?
The Vine City MARTA station is right behind the apartment complex on Magnolia.
And did you figure out how old the defendant was at the time in 2007?
He had just turned 16 the previous week.
So then did you know his date of birth?
Yes.
What is his date of birth?
March 8th, 1991.
And did you do any investigation to see if he had works, maintenance, or any of that sort for the apartment complex back in 2007?
We had contacted the apartment complex and they did not have information that dated back to 2007 available.
And back in 2007, I know you have a 30-year career. Were you a homicide detective back in 2007?
I was.
And in your 30-year experience as a homicide detective, is it common for when there's a burglary, have you, let me rephrase that, have you gone to burglary scenes or armed robbery scenes at a home before, like when you were 30th grade?
Yes,
And you saw the pictures because you were, correct?
yes, correct.
And you saw that the state of the apartment and all the clothes strewn around and what had happened to the apartment.
Yes.
Was that common for burglaries for the apartments that way? Or is this an uncommon occurrence when there's a burglary and there's a invasion of the home?
It's common. There was disarray in the apartment.
So was this disarray in your experience as a homicide detective and your experience as a 30-year police officer? Does the disarray indicate one way or other that the people that went into the apartment are looking for a specific item? Or is that just what happens when there's a burglary?
My experience, it's just a burglary and they're going through as fast as they can, looking for whatever they can find that's of value.
And you worked were you a homicide detective in 2007?
Yes.
In 2007, in your experience as a homicide detective, when witnesses come in, is it typical for witnesses to type their own statement?
Not usually.
And why is that in your experience?
You want the individual to be able to articulate what they saw and have the ability to hear what they are expressing and have the ability to ask questions based on how they're presenting their side of the event.
And when you're talking to, you have different manners of talking to a witness of a crime depending on their relationship to the victim.
Yes.
And so if a witness is a familial relationship with the victim that's dead, is there a different way you talk to them?
You just try to get the story as best you can and be, somewhat compassionate to the individual.
In your experience, do you have a different way of talking to a witness if the witness had just perceived the event and saw, so let's say for a homicide, you just saw the family member get killed in front of them?
Is there a different way to talk to them?
Yes.
I mean, you have to understand the situation, I guess, and go with what works.
And in your experience, in that scenario, your 30-year experience, is it uncommon or common for people to forget things or not forget things, remember things more after they have had a chance to think about the case? If my question is not clear, as I'm saying.
Some people have different reactions to events. Some people remember it clearer a day or two later after they have some time to, recall what they saw as opposed to being right there and just saying it. Some cases that I've worked, we don't take statements for 2 or 3 days just so that people have the ability to recall the event. And some people write it down and then tell you about it. Others want to get it done right away.
So if you hear more information after you talk to the witness on the night of the homicide, it is not uncommon.
It is not, no.
And then from that information, you further investigate the witnesses.
Correct. If you get information 2 or 3 days later, obviously you have to determine where that information came from, if it's something that they heard or something that they were told, or if this is something that they actually recall. It's a little more investigative work on our end to determine where the information actually came from, but it's not uncommon.
When you say our end, who's our?
The police department, the investigators.
And when you read, you said you're going to get back in December of 2018, that it was Defendant Jerry Hodges. What about the other people that were in their apartments? Did you have any information who was before?
No. The other subjects that ran out, no, we had no idea who they were. We still don't know who they are.
Was there any other information that you were investigating that gave you any leads on who those other people were?
No.
After you get back the FedEx from Sergeant Monsiel and you get the match that she picked out at the defendant, what did you do?
Based on the physical evidence of the fingerprint on the screen, the witness statements from Ms. Canada and Mr. Gooden, and then the positive identification by Ms. Gooden, a warrant for Mr. Hodges is obtained for the charge of murder.
And what was the date you got the warrant?
The date on the warrant was the 4th of January, 2019.
Back up a little bit. You said you talked to Ms. Canada, correct?
Yes.
For you, and when you talked to her, did you tell her why you were talking to her?
Just told her I was reviewing the case file and wanted to get her talking about the event to see if she had remembered anything else, and asked her to give me her recollection of the event to see if it was consistent with what she said back in 2007, and it was.
And when you talked to her, did you tell her you were going to show her a photo lineup?
The first time I talked to her, I know I didn't do it then, but I told her that Buffalo Grove detectives would be in contact with her to look at photographs, yes.
When you talked to her, did you tell her that this suspect, person that matched, the defendant that matched the fingerprint was going to be in the lineup?
No.
Then what did you tell her when you told her she was going to see the photo?
Just that we had been looking into the case, some developments had come up, and we just wanted to see if she had anything to offer by looking at some photographs, and she agreed to look at photographs.
So after, moving forward, after you take the warrant out on January 4th, 2019, did you attempt to locate the defendant?
We did.
And did you go anywhere to try and locate?
On New Year's Eve, we had gone to his mother's residence on Bakers Ferry Road and attempted to locate him prior to any warrant being issued and prior to him being identified in the photo lineup. His mother accepted my business card, or I left my business card, and I spoke to her just after the new year, and she indicated that Jerry had come by the house.
Stop for a sec.
There's a
Ms. Ocom?
sex exhibit without, don't tell me what the mother said, just tell me what you did.
We knocked on the door, left a business card, and left.
And
I'm gonna ask a quick question. You left a business card with the mom, or you left a business card like in a mailbox or something?
At the door, in the door.
Okay, did not interact with anyone.
No.
Okay.
And after that, were you notified by patrol officers that they had, patrol officer Holland that he had located the defendant?
Correct. After the warrant was issued, there's a process that we have to go through that puts the warrant on the system. So any officer or individual running a person through the database would be alerted to the fact that there's a warrant for his arrest. And on January 16th of 2019, uniform officers were able to locate Mr. Hodges. They were notified that there was a warrant for his arrest, and he was arrested at that point.
Was he brought down to homicide?
He was.
And did you see the defendant that was brought down to homicide?
I did.
The person that was brought down to homicide on January 16th, 2019, and the person being researched as Jerry Hodges. Is that, Your Honor, I would ask, if I ask so that we see it.
Sure. So ladies and gentlemen in the courtroom, deputies, jurors, spectators, please remove your masks briefly. But I do need everyone to do that so that Ms. Ocom can ask her next question. And then once we're through that, you're welcome to put your masks back on.
Detective, you see the person that you researched as Jerry Hodges and the person that you saw on January 16, 2019. Do you see that person in court today?
I do.
Can you please identify them by pointing to them and tell me a little bit what they were?
And you don't need to point. You can just describe what he's wearing and where he's sitting, if it's a he.
Mr. Hodges is sitting to my right, a little bit over there, about 1 o'clock position, wearing a gray sport coat.
You want to let the record reflect that the witness is identified?
He has. All right, mask back on. Thank you.
And back to when you spoke to Dr. Canada, did you indicate to her in any way that there'd been a fingerprint match?
I don't recall being specific about what the information was that led us to having conversation.
You indicate to her that, so if you don't remember, you indicated to her there was a fingerprint match. You indicate to her who the fingerprint matched to.
No, absolutely not.
Did you tell her the names of the people that she was going to see in the photo?
No.
And the photo that you put together to put in the photo lineup. Do you remember what year that photo was taken from?
2007.
Remember what month in 2007?
I believe it was August of 2007 was the photograph was located, and research indicated that it was August of 2007 that it had been taken.
Also going to show you state's exhibit 49 that had, this was the APHIS hit information, defendant's picture and fingerprint and prints. Is that, when somebody's arrested, you said a warrant for 2019, when he was picked at 16, a fingerprint's taking as well.
Yes, when he's arrested.
So every time, is it every, so your fingerprints are taken and it's uploaded into the system?
My understanding, yes.
I don't know. Nothing for me.
Okay. Ms. Feely, do you have questions for Mr. Zimbrick?
Yeah.
Morning.
Detective, you reviewed the file, as you mentioned, right?
Correct.
And that included Miss Canada's initial statement that very next morning after this incident.
Yes.
And you said on direct that it would be unusual for the witness to type their own statement.
My experience, yes.
But in this particular case, Miss Canada is listed as the typist, right?
I don't have the statement here, but I would assume if you're saying she's listed as a typist, then she's the typist.
Would it refresh your recollection to take one more look at it?
Sure.
She is listed as the typist as her statement, right?
The lead detective is also listed as the witness, Detective Mathis. So based on my experience with Detective Mathis, I know why she typed her own statement.
Exactly. And if Detective
They have
Mathis,
told the jury why that happened too. Something about one finger at a time on the keyboard.
Really fat fingers.
and if Detective Mathis testified that she typed her own statement, then she typed her own statement.
Yes.
I also wanted to talk with you about your experience with interviewing witnesses. You mentioned that a day or two later, sometimes you, with a traumatic event anyway, you sometimes can get more accurate information.
Sometimes, yes.
And in this particular case, it was the day, kind of the morning after.
Correct.
But you wouldn't sit on a witness and interview them 11 years later, right?
I don't understand.
You wouldn't do your initial interview 11
Oh,
years
no.
after the incident.
No.
Right. Or 15 years after the incident.
Correct.
You want to get the statement fairly close in time
Correct.
and give them maybe some time to cool down from it.
Correct.
And you mentioned that part of the reason is because they can kind of become more comfortable with what happened.
Yes.
And sometimes people don't like talking to the police.
Correct.
But that wasn't the case with Dr. Canada.
I don't believe so.
And you said it was not abnormal for people to remember things differently later.
I misunderstood the question then. It's not abnormal to remember things differently?
So you said on direct that it's not abnormal. Sometimes people remember things differently
Sometimes, yes.
than how they actually occurred.
Correct.
And you actually showed the lineup to Mr. Gooden, right?
I did.
And you knew what photo was the suspect in that particular case.
I did.
And so you had to take precautions to not do anything to be suggestive.
Correct. And in that instance, it was each picture was in an individual folder, shuffled up on a table, and I believe it was inside of a McDonald's restaurant. And the 6 folders were handed to him, and he went through them one at a time, and it wasn't in a chronological order. So
And it's your understanding through your investigation that Corey Gooden was actually in the apartment with these men,
very briefly.
very briefly, and within a few feet of the gunman.
Of a gunman, yes.
And he was not able to provide a description of like height and weight, right?
He indicated that he was in there briefly, had a gun pointed at him, and dropped the food and left the apartment quickly.
So no description of like facial hair, hairstyle, tattoos.
He was not very good with what he saw, and he addressed that, saying that he was in an absolute panic and got out.
In 2018, you already talked about you tested the ballistics in this case again.
I just made sure that they were in the NIBIN system,
And
confirmed that they were in the NIBIN system.
and you're talking about the shell casing
Yes,
and the one shell casing that was found at the scene.
yes,
And you, in your review of the file, you saw that the photos show that the casing was actually inside the apartment.
I believe so, yes.
And ballistics can't tell when that was left there, right?
That's correct.
And then your involvement with the Buffalo Grove lineup. You said you sent the lineup via FedEx
Yes,
to show Dr. Canada, who was residing up there.
correct.
At the time, she did provide a description, right?
At the time in 2007,
Yes.
yes, correct.
And now this was 11 years later, is that right?
Yes,
And you had to communicate with the Buffalo Grove Police Department to arrange this.
yes, I did.
And some of that took place via email.
Correct.
Did you review the emails prior to today?
I have not.
So you sent the lineup up there for Miss Canada or Dr. Canada to review 11 years later, hoping that she could identify somebody after that amount of time, right?
To determine if she could identify anybody, yes.
And you were hoping that Dr. Canada had an excellent recall for faces.
As she said on the phone conversation, that she thought she could remember it.
Because it would be truly remarkable to be able to remember that face from that long ago, right?
Yes,
And after that amount of time, it would be a big if she could remember, right?
I've seen better, but yes.
And you asked the Buffalo Grove Police Department to, if she's able to make an ID, then to ask her if it's the 2 runners or the 1 shooter, right?
Correct.
And there was this identification was very important to this case, right?
Somewhat, yes.
Because in your experience as a detective, you knew that that fingerprint on the screen alone was not enough to make an arrest.
I don't know about that.
So the fingerprint on the screen alone, you had before you sent the photos to be identified.
Correct.
And the fingerprint alone did not rise to the level of probable cause to get a judge to sign a warrant.
At that point, correct.
Because the print alone is some evidence that that finger touched the screen at some point in time.
Correct.
But the print alone does not put a gun in Mr. Hodges' hands.
Correct.
That's all I have at this time.
Ms. Ocom, any redirect?
Yes, just briefly. I believe on cross you were asked, was it remarkable that she would remember the photo? You said you've seen better.
Yes.
What do you mean by you've seen better?
I've had a witness pick a individual out of a lineup 19 years after the fact.
So when she picked him out, it wasn't a big surprise to you.
No, not after speaking with her and having what I believe to be an understanding of what she saw and how she saw it and how it had affected her.
Did you do anything at all in any way to indicate to Ms. Cannon? You talked on the phone twice. You talked on the phone twice, right?
At least twice, yes.
To indicate to her that the person would be in the lineup and the person who's Defendant Hodges.
No.
You, was there any, how to phrase the question, is there anything be your interest to ensure that the defendant, I'm sorry, that Dr. Canada or Mr. Gooden picked out the Defendant Hodges? So did you do anything either way to explain, to indicate verbally or non-verbally to Mr. Gooden that Mr. Hodges was in the lineup initially?
No.
Thank you. No.
Any questions from the jurors for Detective Zimbrick? Got a few. Deputy Gordon, please. Thank you. One of you needs to go to penmanship class. All right, lawyers. That one's still just open.
Thank you.
Few more questions.
Sure.
When you were asked by your supervisor to pick up this case and review it, and you got a hold of the official Atlanta police file, did you notice that any normally present pieces of a homicide file were missing?
No.
When Dr. Canada selected, I think it was image 3, whichever image she selected when she was at Buffalo Grove PD, did she indicate who that was? And by that, I don't mean the name of the person, but this was the shooter, or this was someone else who came out of the apartment, or did she specify the role, if any, that the person in photo 3, whatever photo she selected, had in that incident from March 2007?
I believe my recollection is that she indicated it was the individual that came out last, looked at her as she was sitting in her vehicle, like at the drive-in movies, looked at her and turned and fired at Malik. So I believe it was the shooter is what she indicated to me.
In your review of the case file, was there something you learned from interviews with Mr. Gooden, or interview you had with Mr. Gooden, that made you think showing him that same array of photos might result in an identification? That there was some testimony from Mr. Gooden that for one of the people in the apartment, he only saw a forearm and a handgun. And so the question is, why show a photo lineup? Was there a reason why you thought from your interactions with Gooden or your review of the case file that Mr. Gooden would be in a position to identify a face based on what he described seeing in and around the apartment?
Based on my conversations with Mr. Gooden, and the reason that the lineup was shown to him is because as he walks into the apartment, according to Mr. Gooden, there is an individual standing next to Malik in front of him. And as he turns, he sees the gun come this way. So there is the possibility that something could trigger him to identify possibly the individual that was up near Malik. So he was in the apartment. He said he saw one individual in front and saw a hand with the gun on the second. So there was a possibility that he could, and no harm, no foul if you don't try. So he was shown the lineup for that reason.
My understanding of how APHIS works is pretty limited, so I may be asking this question in the wrong way. But at some point, a known set of fingerprints known to belong to Mr. Hodges was submitted to APHIS, and it indicated that there was a match.
Yes.
To the latent prints, the things lifted from the screen. Do you know when roughly the known prints were submitted to APHIS that indicated there was a match, if that's how it even works?
I don't know when the known set of Mr. Hodges' prints were submitted and the identification was made. I know that I requested in late November, early December of 2018 that the prints be researched.
Okay.
So I don't know when Mr. Hodges' prints were available for comparison.
This leads naturally then to the last question I have. Do you know if APHIS is always sort of passively looking for matches, so that when you were doing your work with cold cases, sometimes you'd walk into work and APHIS would have sent you an email saying, hey, we just discovered that these known prints that were submitted 2 weeks ago, just because someone got arrested, matched this homicide scene from 12 years ago? Or is it proactive? In other words, you need to ask a fingerprint expert to submit some known prints and say, hey, let's check. It's been 10 years. Let's see if these known prints hit anything in here.
My experience is that once we review the file, we ask them to research the prints that were recovered on the scene. My understanding of APHIS is that it doesn't shoot back with, this is this guy's print. It shoots back with, these are 10 or 20 prints that have great similar characteristics to the print that you're looking at. And it still has to be researched by the human eye and confirmed by the human technician. So my experience has been the last years that I worked cold case, whether it was DNA or fingerprints, you had to request that the information be manually researched by a tech at that point. The only one that I've ever gotten notification of a match is through ballistics, and that's a constant on the ballistics. Fingerprints are a different breed, I guess, because of the complexity of it.
And it was Mr. McCook, is that the right name, who did the analysis or research at your request with the fingerprints in this case?
Yes.
Ms. Ockham, any follow-up with Detective Zimbrick?
Yes, Judge. We'll start with 39. We'll be talking about number 3. And whose picture is number 3?
Mr. Hodges, Jerry Hodges.
And is the number 3 picture of Jerry Hodges the picture that you found or you researched and got from August of 2007?
Yes.
And I know when we were talking about, you showed the picture to Mr. Good and you shuffled the photos, so they were not numbered 1, 2, 3, 4, 5, 6.
They were numbered 1, 2, 3, 4, 5, 6. Just they were in folders, plain manila folders, and shuffled up on a desk. So I don't know which one he looked at first. He could have looked at number 5 first. He could have looked at number 1 first. I don't know. He looked at all 6 individually and said he could not make an identification.
Okay, so the numbers remain the same, but the order of them are different.
Correct.
And is that what you typically do and what you tell when they're showing for the race student?
Yes.
And why is that?
So that there is no suggestive effort made on anybody's part to identify a particular photo for the investigative purpose.
Thank you.
Ms. Feely, anything else for Mr. Zimbrick?
No, you're.
When did you move to Tennessee?
2019, shortly after I retired.
All right, congratulations. Back to Tennessee for you. Thanks for your time. Ms. Ockham, I believe, well, let me ask this. Do you have any other witnesses that you plan to call?
No, Judge.
Okay, but at this point, you are going to play an excerpt, video only, from State's Exhibit 75.
Yes.
And Ms. Primovic, you are maintaining the objections, several bases that you've made, some in front of the jury, but we've also discussed this outside the presence of the jury. You're maintaining the defense objections to the publication, this is already in evidence, but to the publication of this part of the video.
That's correct.
Okay, those objections are renewed and preserved. And we will let you take over. Hopefully you can make share screen work.
Yes, Judge. For purposes, just for the record, I'm playing State's Exhibit 76 and the portion that I'm playing without sound. When Dr. Patterson was giving the photo array by detail and
So State 76 is a body cam from Officer Holland.
75.
Okay.
And then the timestamps I'm playing you from about 4:10 to 10. To 10-minute mark.
So it's a little under 6 minutes.
Yes, Judge.
Okay. All right, Ms. Okam, anything else from the state?
Your Honor, just one more thing. I stopped at 11:57. I think prior I said 10 something.
You did. You said 10 and we went past that.
Yes.
It's okay.
11:57, Your Honor. Thank you. No, nothing further from the state rest.
Okay. Ladies and gentlemen, at this time, the state has rested. They've presented to you the evidence in their case in chief. This is a natural break point. It is a little early for your break, but it's when you're going to start your break. That announcement that the state rests triggers a number of conversations I need to have with the lawyers and Mr. Hodges outside your presence. So this break will last longer than your usual morning breaks. Be at ease. Don't start talking about the case. There may yet be a defense presentation. Mr. Hodges has no burden in this case to prove his innocence. The burden is entirely on the state. But Mr. Hodges has a right to call witnesses and the ability to subpoena witnesses if that's what he and his legal team want to do. So I need to talk with the lawyers about what's coming next. There are also a couple motions that are naturally raised after the state says we rest, and I'll need to hear those motions and rule on those outside your presence. So we'll see what's coming next for you all. Could be a defense presentation. It could be that we hear the defense rests and then we shift to closing arguments. Either way, I need you to not talk about the case or do any outside research during the break. Feel free to use that hallway if you need to spread out a bit, and we'll get you back in here as soon as we can, but it will be a little bit. Thank you. All right, you all can be seated. Ms. Love, we'll see you in a little bit or whatever you need to do.
I was just trying to get an idea of how long the break was and what you were about to do.
So I'm going to see if the defense has any motions. I will rule on those if they've got them. Then I'm going to have the conversation I need to have with Mr. Hodges, and then we can take a short break. But we need to finish our charge conference, which I think we'll do now. In particular, if the defense isn't going to be putting up any evidence, then we've got to do it now. So you can go at any point, but there will be a break for everyone after we handle any motions, and I have the conversation I need to have with Mr. Hodges. Okay.
Assuming nothing from the defense, will you go into first close before lunch?
Yes. So at this time, Ms. Primovic or Ms. Feely, any motions from the defense?
Your Honor, we have just one motion for a directed verdict. As you know, 17918 provides for directed verdict is followed when there is no conflict in the evidence and the evidence introduced with all reasonable deductions and inferences shall deem a verdict of acquittal or not guilty. Your Honor, we're only doing this directed verdict on count 5, which is the armed robbery. The armed robbery is, as stated, 16th day of March, did unlawfully with the intent to commit that, take a camcorder, the property of Malik Barry Buchanan, from his person and immediate presence by use of the handgun. We have no witnesses of that. There is no evidence whatsoever that was brought forward concerning this armed robbery, not one shred. And so we're asking for a directed verdict of acquittal on count 5, the armed robbery.
Okay. I think there is a felony murder count predicated on that. So that would fall.
The same, Your Honor, which would be count 2. So count 2 and count 5. Thank you for the reminder.
Sure. Question before I hear from Ms. Okam. Was there not an exhibit that the state admitted that was a picture of the camcorder out in the, I'm gonna call it the front yard, that there was something that I think the ID tech, someone talked about, like, oh, this is a camcorder.
Absolutely, Your Honor.
Okay.
There was also other clothes strewed around and all kinds of things that were taken by the 3, if not 4 people running out of the house carrying things. There was no evidence that this was taken from the person or immediate presence of Malik Barry Buchanan. They're not saying it's a theft. If they would have said this is part of the burglary or this was a theft from the house, that they proved, but they did not prove. I never heard one piece of evidence that this was taken from the person or immediate presence of Mr. Barry Buchanan.
Okay.
By the use of a handgun. Then that's
Got it.
counts 2 and 5. Thank you, sir.
Thank you. Ms. Ocam.
Judge, I believe there was also evidence that the camcorder that was on the scene belonged to Ms. Gooden said that it belonged to the house, and they all had ownership of it, of the camcorder, and I believe, if I'm clear, her argument is not that camcorder wasn't taken, it was the presence or from Mr. Buchanan.
Right. So, and I appreciate Ms. Primovic refining it. She is not saying there's no evidence that it was taken, but that in fact, there's no evidence that it was taken from the person of or immediate presence of Mr. Barry Buchanan. And so I'm interested in hearing from you if there's any evidence that the camcorder was on the couch next to Mr. Buchanan when it was taken, or it was actually upstairs in a bedroom. And so when one of the perpetrators put it in the pile of clothes, Mr. Buchanan couldn't have known it happened because he couldn't even have seen it. And I don't remember if there was any evidence to that effect. I do remember what you said, which is that Mr. Gooden said it might have been Xavier's camera that he used because he makes music video, but we all used it. It was communal. And the argument wasn't that it wasn't Mr. Barry Buchanan's video camera. Again, I think the focus was, but Ms. Primovic will get the final word. So if I'm putting words in her mouth, so say, stop it, Judge. It's how do we know, if we know at all, that it was taken from Mr. Barry Buchanan? No evidence of that, or at least in his immediate presence, whatever that means under the law.
Your Honor, I believe we're looking, that's what Ms. Law was looking at, but I believe the statute also says for the definition of it, a person may be deemed to protect all things belonging to that person that are within an area over which the influence of that person's presence extends. So if it was obviously in the house, clearly, because he brought it out of the house, that's how it ended up on the floor that the crime scene technician is able to take. So the state's argument is that obviously, if the statute is saying that it's in his person's presence, it doesn't have to be right in front of me. But it's clear that the camcorder obviously came out of the house. And so that would encompass, for purposes of this statute, presence. And, well, I mean, there's no evidence, because obviously nobody was there when he was doing the home invasion. But there's evidence, you can infer circumstantially that the camcorder came from the house. According to the statute, it's where he has influence over. So the state can argue that in our closing, that obviously to go to the jury, there just has to be some evidence. We don't have to prove it beyond a reasonable doubt, just have to have some evidence that it happened. So based on that category and what we have to climb or come over to get into the jury, I believe the state's argument is that we should deny defense motion to direct very quickly on our way in from the account that's just it.
This is an interesting legal question. I find that there is not evidence as to specifically where the camcorder was when it was taken, other than it was inside the apartment. And I think Ms. Primovic would agree to that, but again, she'll get the final word here. I'm going to defer ruling only because I need to do some legal research. I think the legal research that I'll do is, what does immediate presence mean? I think the evidence is sufficient for the jury to consider this count if immediate presence could include anywhere in the apartment, because we know it came from somewhere in the apartment. And frankly, it might have come from right where all the electronics were. My guess is what the evidence would have been had someone talked about it, but I don't think that's in the record. So I invite both sides to look at some case law. I know Ms. Love already pulled one thing up. I think that's still, we need more refinement on what that means. And I bet there's a case out there that says, well, if it was taken from a room in which the victim was not sitting, that's still okay because it was taken from his presence in the house. Or that's not okay, and okay is the wrong word. It's not sufficient because that victim didn't necessarily know that that was being taken. And so how is it a robbery as opposed to a theft? Because all of this would be theft if no one was home. What is different here is that Mr. Barry Buchanan was home and witnessed a whole lot of it. And I think even Mr. Gooden could be deemed to be a victim of robbery because some of it was taken from his presence. So I think it's a legal question, not so much a factual one. Ms. Primovic, anything? Ms. Love wants to add something. Ms. Love.
Briefly, Judge.
Sure.
I just wanted to point out while Ms. Oakland is doing further research that in order to get out of the house with the camcorder, all of the people that were there necessarily took the camcorder past Mr. Buchanan within feet of him. So they necessarily took it from within his immediate presence because of the proximity that they were in to him at the time that he was in the downstairs area and they were all escaping the home.
That thought crossed my mind as well. And so then I just don't know, does the victim need to be aware that something is being taken? Is it a theft because it came from upstairs, but it's a robbery because there was something in Mr. Barry Buchanan's pocket or on the table in front of him? I don't know the answer, but I think you make a compelling argument that there's no theft here at all. It's all robbery because of those facts that are in the record. People surged by or directly behind Mr. Gooden. Everyone had to go by Mr. Barry Buchanan. And then, of course, Mr. Hodges, who's party to all this, was sort of side by side and they interacted. So I think it's a legal question, and I'm going to do a little research, and I invite both sides to do that. But Ms. Primovic, if you think I am laboring under a faulty recollection of what the evidence is, let me know, because I want to make sure I'm factoring in your view of what you think the record shows.
Yeah, Your Honor, none of the witnesses said that this camcorder was sitting next to the couch where when I looked in and I saw him, when I looked in and I saw Malik sitting on the couch and he did the old, incomplete pass, oh, and the camcorder was right next to him. Then I'd be like, wouldn't have brought this up, but there's absolutely no evidence of that.
Okay. So there's evidence that it was in the house, and there's evidence that someone carrying it at some point was kind of near Mr. Barry Buchanan, and that's what we've got. And so the question is theft or robbery. Okay. So I'm not denying the motion. I don't think we need to work through that quite yet. I need to do a little research, and I shall. And again, I invite both sides to contribute case law as well. Why don't we take let's reconvene at 10:40 to talk about the rest of the jury charge. Does that work, Ms. Ocom?
Yes.
Ms. Primovic? Oh, no, not quite yet. Mr. Hodges, I need to ask you a few questions. If you don't mind taking off your mask so that the court reporter can hear you real clearly. Mr. Hodges, do you understand? First of all, can you hear me?
Sir.
Great. Do you understand that you have a right to testify, and that if you want to testify, no one can prevent you from doing so? In other words, your lawyers may say, that's the dumbest idea in the world. They may not, but they could say that. It's your call in the end. And if you want to testify, you have an absolute right to testify. Do you understand that? Do you understand that in the reverse, no one can compel you to testify? The state can't call you as a witness. And even though your lawyers may be telling you, you better take the stand, you have the absolute right to say, I do not want to testify. Understand that? Do you understand that in the end, and the end is coming in a few minutes to our conversation, it's you who will decide whether you're going to testify. I will not be asking Ms. Feely. I won't be asking Ms. Primovic. I'll be asking Jerry Hodges, do you want to testify in your case? You understand you're making that decision?
Yes, sir.
Do you understand that if you choose not to testify, I will be telling the jury that they are to draw no conclusion from that fact at all? I'll remind them that you have no burden of proof, and the fact that you choose not to testify is a non-event. That's not something that they consider in their deliberations. Do you understand that I'll tell the jurors that?
Sir.
Do you understand that if you choose to testify, not only will you answer all the questions from your lawyers, which will generally be easier questions, but you'll have to answer all the questions from the prosecutors as well. Those will be less easy questions, and you don't get to say, well, I take the fifth. You answer every proper question from both sides. You understand you'll have to do that?
Sir.
All right. Well, understanding all that, Mr. Hodges, do you wish to testify in your case?
Yes, sir.
I find that Mr. Hodges has made his decision not to testify with a full understanding of his rights and the consequences of exercising those rights, either in the direction of testifying or not testifying. Mr. Hodges will not be testifying. Ms. Primovic, when we get the jurors back in here, any other evidence that the defense will be putting on?
No, Your Honor, the defense will rest.
Okay, then let's take 7-8 minute break. Once Ms. Rivers is able to get back behind the court reporter steering wheel, we will finish up our charge conference. And then at a minimum, we will, Ms. Ockham, do you know if you are opening and closing, or the state is doing both pieces? My last trial, the state surprised me and said, we're only doing rebuttal.
We're splitting, Judge.
You're splitting.
First close and second.
Okay. Well, at a minimum, we will do the state's first close. Depending on when that ends, we may do the defense closing, depending on how long that will be. I have a 12:30 Zoom session I have to be on. So that's our hard stop. The jurors are going to get a plenty long break. They can make it till 12:30. And so we'll just see if we're going to, when people stop talking, where we are in that process. Okay. All right. I'll be back out here in about 6-7 minutes and we'll finish our charge conference. Thank you.
Thank you. Do we have ginger?
Yeah.
Yeah, he said, wow. No, it's for the. It's for the. To get that over, and so it's all.
Oh, you guys split. Really? Whatever you do. Second part. Get into it. What you worry about? I don't know.
hate you so much. Why do you always make me tell me stuff? What is wrong?
I'm old.
I hate you so much.
Do you like everything?
I eat these Skittles and sugar, and every time I see you, you talk to me. I hate you so much. Like, this is ridiculous. Oh, look, you couldn't like have like
Can you get all
like
like,
sugar
you know what, I'm starting.
no sugar like one day just to make you feel better.
I am not.
I've had
I'm more of a
big
salt.
bags of Skittles.
Chocolate version or salt?
I hate you. Chocolate is healthy too. I hate you.
I have one, I have an extra one.
I like
Of course, to have figs. Anyone wants some figs?
I hate you. I'm sick. Is that okay?
It's good for your stomach.
Okay. How do you stand? Sit by her and watch her feel this house.
That you only ever see me eat bananas and figs.
Yeah, I remember for 3 months and I've never seen anything else until the other day.
I cannot. We have to separate because this is really ridiculous.
Or eat a whole pizza.
No, please stop.
They're talking. Once I stepped out, they're talking. Yeah. They good now, wow. Yeah, I was right here, I heard. No, it's English. 15, 20. No. You just see you coming at the end of the story, you can't do that because then you get wrong information.
Oh, no, it probably isn't, but so that is my problem. Sticker.
At. What's your email address? What's your email address? Give it to me. Give it to me. All right, I'll just send you something. Just Did you try it? Hover all trees. Right click, right click. You see what you do, you see copy. Hit file upload, hit file upload. Now, put the pointer on that file, and you hold it down, and you drag it, just flip it over. Anywhere. Did you have that? What does it say?
What time do you say he's coming back in?
7 months.
So can I get it?
Yeah, I got you.
Ms. Rivers. Can we bring Mr. Hodges out, please? Thank you.
Judge, Ms. Oakham, just a
Okay. How are you doing?
little bit better.
Okay. Got your
It's not,
mellow yellow.
it is not ginger ale, so I figured I'd just chill out with that. It's a little sweeter than I expected.
Stomach issues today?
Just, I mean, it started Friday, we started, actually. You were sick?
I had some last week and some, a lot of drainage
Miss-
today.
I did too, earlier this morning. Stop putting that on.
That apparently got a couple of your colleagues out of a trial this morning. Hope everyone's okay.
out for the count.
Really? COVID or just sick?
COVID. Nine and rings and one of the first.
What order?
Georgina.
I don't think it was.
Ms. Rivers, you ready? I want to return first to the motion for directed verdict. My crack research team helped me find a couple cases, and then we can finish our charge conference. Based on the case law that I have found, and I'll get those citations into the record, I'm going to deny the motion. Mr. Hodges, your lawyers did a good and thoughtful job about making their motion for directed verdict. A directed verdict motion is basically when the defendant says the jury should not be able to decide this one because there is no evidence upon which they could reasonably base a guilty verdict. And Ms. Primovic tailored it to the evidence that we've heard. I would have very quickly found that there is evidence that a jury could consider that would authorize a guilty verdict as to the other counts. Not that they will necessarily do that, but that they might. But this armed robbery was an interesting question. The case law that I've found helped me understand that this concept of immediate presence can extend fairly far, and it can be beyond line of sight. It's not infinite. If I am here and someone breaks into my house and they take my stuff, that's not armed robbery. But the facts of this case fit fairly closely the facts of other cases where there is a robbery, armed or sudden snatching. Really, that piece doesn't matter so much. Or something's taken from another room. And the earlier cases I found, the Court of Appeals said, well, the person knew it was taken, even though they couldn't see it taken initially, or they could even see it in another room. And so the focus was how far is immediate presence. The Perkins case at 256 Georgia Appeals 449 talks about that range extending pretty far, as long as the object or objects that were taken were under the control or responsibility of the victim. And I don't think we've got that issue. We have testimony that the camcorder was sort of all three roommates. And so that box is checked. But those cases that were older all involved the victim being conscious of, aware of that an item was taken, a purse, a wallet, something like that. Either because when it was taken from a room where the victim couldn't see it, the perpetrator then came back through and by the victim, and the victim could see, hey, you've got my, pick whatever the item is. We don't have those facts. And so I struggle a little bit with the consciousness of the fact that something had been taken, because I think we're within the immediate presence space. I find that Mr. Barry Buchanan's presence on the couch would extend to the apartment. It's not a 100-room mansion. It's a small apartment. And yes, there's an upstairs and a downstairs. But to Ms. Love's point, everyone is passing by him one way or the other. So either he could see it or folks are going by him. The question then is the consciousness of the taking. Does the victim have to know that you took 3 rings out of a drawer in the room? I know you went through that drawer. I could hear it. Do I have to know you took all 3? Do I need to see all 3? Do I need to call out after you, hey, you took the 3 rings? Or do I just need to know that you are taking things of mine or my roommates from my immediate presence? And very recently, in the case of Stokes versus State, 362 Georgia Appeals 223, the Court of Appeals declined to hold that a victim's consciousness of the taking is an essential element of armed robbery. It is simply enough that the victim know that his or her property is being taken. And if you think about it, that makes sense. You could have a home invasion where the victims are bound and blindfolded and pushed into a closet. and then things are taken from their house. That's an armed robbery. They may not be able to tell the police right then and there, these were the things that were taken, but their property was taken from their immediate presence through the use of an offensive weapon. And I think that applies to the clothes, the camcorder, et cetera. Whether I'm extending immediate presence too far or relying too heavily on Stokes's consciousness of the taking not being an essential element can be determined should there be an appeal, should there be a conviction as to the armed robbery count, meaning count 5, but counts 2 and 5 will remain in the indictment. Ms. Primovic, anything you want to get on the record concerning your motion?
No, Your Honor.
Okay, thank you for making it. Let's go back to the jury charge. Ms. Ocom had the late Sunday request for several additional charges, and I will talk about all 4. The first was presumptions and inferences, and let's get our jury charge back on the screen. So on page 9 is the intent charge, where we talk, there's not a presumption to have acted with criminal intent, but that's, I think it's the direct and circumstantial evidence is the language that jurors are free to use reasoning and common sense to make deductions and reach conclusions. So tell me, Ms. Ocom, what's the purpose of adding the presumptions and inferences, and how does it fit in this case? That's the charge that reads, I won't read it all, that people are presumed to be of sound mind and discretion, and that the jurors may infer that the acts of a person of sound mind and discretion are the product of their will. This is not an accident or mistake case. We now know Mr. Hodges isn't going to testify, so he's not taking the stand to say, I didn't mean for the gun to go off, or it was just in the bundle of clothes. So I'm trying to figure out how this comes into play.
Judge, that was one that I had sent to Ms. Ocom as an addendum, and reading it in conjunction with the court's draft charge. I would still say that it's applicable, but it's not one that we're gonna fight over getting in. It just, given that the defendant was just turned 16, I think we want the, issue of, his ability to form reasonable thought and things of that nature to come into play and sort of begin influencing the jurors' decisions.
Okay. I get a little nervous about this one because it starts to introduce this concept of, is there a mental health issue at play? We've got no evidence of that. We have Mr. Hodges' young age in 2007, but that's already in play. I'm going to not give presumptions and inferences, but I'll make sure the defense has no objection to that. Okay. Then we get to party to a crime and conspiracy a little bit more. The second request from Ms. Ocom was to charge about the failure to prosecute the principal, but specifically it reads that any party who did not directly commit the crime may be prosecuted for commission of the crime and that they were a party to it. I think that makes sense as long as it's not too, it makes sense. I think it makes sense putting it in. Let me see what we've got about party to the crime already in. So the bottom of page 9 is the party to the crime charge. My proposal, Ms. Ocom, is to add a phrase we'll do it in real time. Well, I don't think we need the entire 14211 because there's that language about not been prosecuted, convicted of a different crime or degree of crime, amenable to justice, acquitted. None of that applies here. What is it that you want to be able to argue in closing, or you're worried the jurors might not understand in connection? I mean, I think you don't have an issue with the murder. There's no evidence that one of the other guys shot Mr. Barry Buchanan. So maybe it's part of the armed robbery. Who knows who took the camcorder? But one of the guys took the camcorder out of the place. And so that's where it may fit. So what is it you want to be able to argue?
I want to be able, because I believe one of those jurors asked about the other people and who the other people are. So I wanted to be clear that it doesn't matter if we charge them that they're not the people in front of them and the other person is the defendant. And we're alleging he's the shooter, obviously, but the fact that the other armed robbers were not, doesn't have anything to do with the fact that he can be guilty of this. For example, we don't know who exactly took the camcorder out. We don't know exactly where they went, but we know that as part of the robbery, the camcorder came out. So even though I can't say that the defendant was the person that took the armor, I would be arguing that he is because the other people did.
Sure. So what if I incorporate the language that you now see at the top of page 10?
Yes.
That way we leave out the not amenable to justice or acquitted. I don't want these jurors worrying about, wait, has there been another trial? This is proper legal language, and I think it then enables you to address that concern. And you know what? Really, jurors, you don't need to figure out who took the camcorder if you conclude these folks were acting in concert. If Mr. Hodges were a party to the crime, which would mean that he intentionally helped in its commission, if he didn't directly perpetrate it, then he's a party and he's criminally liable. Ms. Primovic, any objection, or Ms. Feely, to the addition of that sentence to the parties to crime charge?
Yes, Your Honor. For purposes of the record, we are objecting to both parties to the crime charge and the conspiracy charge.
Oh, we haven't gotten to conspiracy yet.
Okay.
Tell me why we hadn't gotten to it, but now's the time to bring it up anyway. When I was going to ask the defense if you have objections to what I've included, you had an objection to the two sentences already in the charge at the bottom of page 9 about parties to a crime. And so anything adding to it, you furthers your objection. What's the objection?
So we have the fingerprint, which can't be put a time on. And so the only other evidence is the eyewitness testimony that he was the shooter. And there's been nothing else. So there's not even slight evidence to support that a party to the crime charge.
Well, I'm confused by that. There's been more than slight evidence that there were at least 3 young men in the apartment, and some evidence that Mr. Hodges was one of those, emerged with Mr. Barry Buchanan, had belongings not of his own in his arms, and then ultimately shot Mr. Barry Buchanan. So how would parties to I understand you may not like it, but what is the lack of evidence that there were some people acting in concert? I understand it's not the classic conspiracy where there was a wiretap or one of the defendants testified saying, hey, you know what, we had been hitting different apartments in the Magnolia Way apartments, and this just was a night that went real badly for us.
I understand that there was more than one person alleged to have been involved, but he has only ever been identified as the person with the gun. He has never been, nobody's given a description of the other 2 that would put his identity as being one of them.
Okay. Your objection is noted. I'm going to leave parties to a crime in. We'll come to conspiracy in a minute. And I will also include the sentence that is now at the top of page 10 that is drawn from 4211. All right, let's get to the conspiracy charge. Tell me, Ms. Ocom, why at the late hour you're adding conspiracy? It's not charged in the indictment, doesn't have to be, but it's not. You had been comfortable with parties to a crime, which fits the facts of this case. Now, all of a sudden, you want to have the jury thinking about unlawful enterprise and people associating themselves by way of an agreement. It adds some complexity that I don't know you need, but I'm also curious legally why you think it fits.
Just that was me again.
Okay.
It almost feels like you knew it was me. Because first of all, the following charge after that, conduct in presence of parties, yes, party to a crime does speak to the fact that if one does it, they all do it. But the fact that they all agreed and went into Malik Barrett Buchanan's home together, and the fact that they then left together, the fact that they rummaged together, allowed this charge about conspiracy and an agreement, even if it's not an express agreement, their actions show that they did have that agreement. And it just further solidifies the charge regarding party to a crime. And it explicitly says, and this is the reason that I wanted the conspiracy charge, each person is responsible for the acts of others, or rather, when persons associate themselves in an unlawful enterprise, any act done by any party to further the unlawful enterprise is considered to be the act of all the conspirators. So in this particular case, you have only one bullet being fired, and you have previously a question from a juror: is it possible that he's the one that took the screen off the window and one of the others fired the shot? And so the fact that the conspiracy charge has within its language an explicit assertion of the law that the act of one is the act of all, because they engaged in this unlawful enterprise together, I felt that it would I don't want to use the word to comfort, but it would help the juror to better understand the law on the point of parties to a crime, as well as presence, companionship, and conduct, further helping that juror to understand the concept of parties to a crime. Because even though it feels very familiar to us, I personally sometimes forget that the people on the jury just don't know or have as much knowledge about these charges as we do.
Sure. Okay. So Ms. Feely, why don't you tackle both of the remaining two requests? So conspiracy and conduct and presence of parties. You've previewed you object to them, but now flesh that out.
Yes, Your Honor. So in terms of conspiracy, I think it's just unduly confusing. I think the parties to a crime is enough to establish what the state wants to, if the state wants to argue in the alternative. But I think this wordy stuff about an agreement, there's been no evidence of what happened before, what happened after, or anything that would go further to say that would need this conspiracy language. I think party to a crime is more than sufficient.
So I'm going to work backwards. The conduct and presence of parties, I don't think fits here because it involves things that happened before and after the commission of the offense. And the only evidence we have is that some number, 3 or more, were in the apartment when Mr. Gooden showed up, and then they all ran in different directions afterwards. We actually don't have any evidence about presence, companionship, or conduct before or after the commission of these offenses. Those are unknowns. There are plenty of cases where the state is able to put up some information that, hey, these guys rode together from one of their houses all the way to the scene, but we have none of that here. So I wouldn't be giving conduct and presence of the parties, even if I gave conspiracy. But I agree with Ms. Feely. I think that the state will be able to address, I don't know that it's even a concern. It was a question of one of the jurors about the connection among the three or more people who went into the apartment and who was involved. But I think that parties to a crime is that sufficiently elastic legal theory that allows the prosecutor to say, in some respects, it doesn't matter who did what. If jurors, you conclude that each of these gentlemen was working together in connection with this, it's not charged as a home invasion, but basically it was a home invasion. So I think parties to a crime covers that. And with the addition of that second sentence that lets the jurors know it really doesn't matter whether the person who is being prosecuted here today, Mr. Hodges, was specifically the one who took the camcorder or did the other thing, if he was a party to the overall situation that was going on in March of 2007. So my ultimate ruling is I'm incorporating that clause from 142.11, and then the other three requests I will be omitting. Having made that ruling, Ms. Ocom or Ms. Love, was there anything else in the draft charge that you got yesterday that you wanted to discuss?
Not from the state judge.
Okay. Ms. Feely, anything from the defense? Then I will get you all a final version. It will be shorter because I'll be taking out the many paragraphs about statement of the witness, of the defendant, as well as the intent to steal and meaning of entry. And we will, I'll get you that final version. I think it's about time to bring the jury in. Ms. Ocom, do you need a minute to get your, I don't know which one of you is giving the first half of the closing. I don't mean to put it on your shoulders.
Yeah, Ms. Love is doing the first, because we need to take out that part, that you just said, that's not gonna be a jury instruction, so if we just need 2 minutes to use that.
5 is fine. Are you gonna be all right?
Yeah, I'm gonna actually go faster than I normally go, so, because I want Ms. Oakland to have the bulk of, the closing, if the court would just let me know after I'm about 5 minutes close to 30 minutes.
Okay, so you want to have about 30, but don't tell you at 30, let you have a glide path into 30. Yep, sure, I'll do that. Then why don't we try to get the jurors in at around 11:20 on that clock? Can you let them know that they need to be ready to go in about 4 minutes? Thanks.
Go ahead. She's for-
All right, Ms. Love, can we bring the jurors in?
Yes.
Okay, and again, what we'll do is I'll start by asking Ms. Primovic to call her first witness. She'll rest. I'll let the jurors know what that means, and then we'll pivot to the state's first closing. Let's bring the jurors in, please. Thank you, Deputy Gordon. Thank you, ladies and gentlemen, for your patience while we work through the various things that come up when the state rests. As I mentioned, it is now time to see if the defense will be putting on a case. Ms. Primovic, would you call your first witness?
Your Honor, the defense rests.
All right. So the defense is rested, which means now the evidence is officially closed. You have heard all the witness testimony that you'll receive in this case. Any exhibit that was going to be admitted has now been admitted. And it is time for the lawyers to share with you what they think the evidence has proven or has failed to prove. The lawyers will be spending the next couple hours arguing to you in an effort to persuade you, which is perfectly appropriate, that you ought to decide the case this way or that way. Reminder, nothing the lawyers say is evidence. And so if one of the attorneys insists that witness X said that it was 100 degrees out, and you're recalling that it was March and it was cold and all that, it's your recollection of the evidence, not the lawyers. What they say is not evidence, just like what I say is not evidence. The state, because it has the burden of proof, has the chance to open and close with closings. In other words, they get to speak to you twice if they want to, and they have elected to do so this time. So in a moment, Ms. Love is going to start the state's closing argument. She's going to go for a little while and then she'll stop. And if we've got enough time, then we will hear from Ms. Primovic or Ms. Feely with the defense closing. And when that's done, then the state will have a chance to, they call it rebuttal. It doesn't have to necessarily be a counterpoint to everything the defense said, but the state will have a final word with you all. Then I'll give you the charge, as in the law that you must apply to this case, and you'll be off and running with your deliberations. So with that, Ms. Love, when you're ready.
Thank you, Your Honor. One shot from this defendant's gun took Malik Berry Buchanan's life. One shot is the number of chances that we get to hold him responsible. And one witness is sufficient to prove the state's case beyond a reasonable doubt. One witness is sufficient for you to hold this defendant responsible for senselessly, for needlessly taking the life of Malik Berry Buchanan. This is the case of the state of Georgia versus Jerry Hodges Jr. This defendant. We're here because the state has accused him of taking the life of Malik Berry Buchanan. We're here because he has said, state, you gotta prove your case. And we're here to give him his fair trial. Each and every one of you were chosen because you said you will give this defendant a fair trial and you will give the state a fair trial. And in doing so, you give Malik Berry Buchanan a fair trial. This defendant did not have to kill him, but he did. And so now he's here and he's got to answer to you. Before we get started, one of the first things I'd like to talk to you about are the jurors' duties. It's really simple and it boils down to about 3. Seek the truth, follow the law, and deliberate. And the place that you seek the truth is in the evidence presented on the stand, the witness testimony that you heard, and the exhibits that you saw. The court has charged you that you're not to go out and use electronic devices and go do Google searches and things of that nature. The evidence presented in this courtroom throughout the course of this trial is where that truth is to be found. the witnesses' testimony, what they saw and heard, the physical evidence, what you're able to see and touch over the course of this trial. That's where the truth lies. And to that truth, you are to apply the law that the court will give to you at the end of this trial. It'll be in the form of a packet, and it'll be back there with you for you to refer to when you need to. And deliberate. Each of you has patiently been here throughout this extremely important process. Because this process isn't important just to the state of Georgia. It's important to this defendant that you all pay attention. And it's important to the family of Malik Berry Buchanan. And it's important to you because this is your county. And what happens on the street of Fulton County matters to you. That's why we chose you. Seeking the truth doesn't mean that you go to the internet or you speculate about theories or you make conjectures. It simply means you look at the evidence and you figure out from that evidence what happened. It means you look at it and you see that this defendant on March 16th of 2007 took the life of a promising young artist, a father-to-be, and a wonderful human being. The court is going to give you the law, and like I said, you'll have it in a little packet with you when you go back into the jury room. You'll also have with you the exhibits that are allowed to go back with you in the jury room. And while we're on the topic of what goes back in the jury room, you won't get a transcript of any witnesses' statements, but there may be items that were admitted as evidence, perhaps the recording that you saw. As long as you saw it once, if you need to see it again, bring it to the attention of the deputy, and the deputy will bring it to the attention of the judge. So let's get into what we're here for, because the defendant has been charged with some pretty serious offenses, and we need to dig into them a little bit. Count 1, he's charged with murder. Count 2, 3, and 4, he's charged with felony murder. That doesn't mean he killed 4 people. It just means he committed acts which are violations of the state laws of Georgia, and these acts are committed in different ways. He committed armed robbery. He committed burglary, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony. For all of these offenses, there are certain things called elements that the state has to prove to you. Intent is one of them. For each and every offense that is charged in the indictment, the state has to prove intent. Now, intent doesn't mean he intended to commit a burglary. You'll hear the court tell you it just means he intended to commit an illegal act. He intended to go through the window. He intended to point a gun. He intended to pull the trigger. The state also has to prove venue. That's just a fancy way of saying it happened right here on your streets in Fulton County. If it had happened 15, 20 miles up the road somewhere in Cobb County, you wouldn't be the ones to hear it. We had to bring it to you because you're the jurors that it matters to the most, and that you're the only ones who can hear this case. The court is going to charge you that a person is guilty of murder when that person unlawfully, with malice aforethought, causes the death of another human being. I've been prosecuting these cases for a while, and that word, that phrase, malice aforethought, I kind of take it for granted now. So I forget sometimes that it's a word that people don't use in everyday language. All that it means is an abandoned, malignant heart, just a mean, nasty heart. Malice can be either expressed or implied. The court will charge you that express malice is that deliberate intent to kill. And how do you find express malice? Well, if someone points, as this defendant did, a loaded firearm at your body and pulls the trigger, aiming it at your heart or thereabout, that's evidence of an intent to kill. Implied malice means that there was no provocation. You were just mean that day. If you find either of them, then there exists malice. Murder does not require premeditation. Some of you were asked what television shows you like to watch, what movies you like to see, or what genres you like to read. And a lot of times in a lot of other jurisdictions, we'll see things about premeditation. Not a thing in Georgia. He did not have to get up and think that morning, I'm gonna go kill Malik Berry Buchanan. That's not a thing in Georgia. Here in Georgia, the court is gonna tell you that malice can be formed in an instant. When he walked out of that house, when he pointed that gun, and in that instant, he decided to pull that trigger, malice was formed. This defendant intended to kill Malik Berry Buchanan. He didn't have to. He could have run like his fellow robbers, but instead he calmly raised that gun. He calmly pointed it at Malik's chest, and he calmly pulled that trigger and kept on going. A person is guilty of felony murder, and remember I told you not 4 different people, just different ways. When that person kills another during the commission of a felony. In this particular occasion, this murder was committed during the commission of a few felonies: burglary, aggravated assault, armed robbery. Malice is not required for you to find the defendant guilty of felony murder. All that's involved, the defendant is involved in a felony. During that felony, somebody other than the defendant dies. The defendant is guilty of felony murder. The defendant has been charged with felony murder predicated on armed robbery, meaning that he caused the death of Malik Berry Buchanan during the commission of an armed robbery. And a person is guilty of armed robbery when that person takes another person's property, Malik Berry Buchanan's or the house camcorder, remember? Directly from the person or immediate presence of another. He had to walk right past Malik Berry Buchanan, he and his co-conspirators, to get out of the door with those items that didn't belong to them. Malik was being held at gunpoint. One of the elements of armed robbery is that you use an offensive weapon. This defendant had a gun, as did one of his other cohorts, and that you intend to commit a theft. The rummaging is evidence of that intent. The fact that when they ran, they're dropping these people's property all along the apartment complex, Brownways. They left that townhome with the camcorder and those clothes. And in their haste to get away, they dropped them along their path. He is charged with felony murder predicated on a burglary. That means that during the commission of this burglary and their efforts to get away from it, the defendant caused the death of Malik Berry Buchanan. Now, a person is guilty of burglary when you enter the home of somebody else. They came in through the window. Without authority, they had Malik Berry Buchanan at gunpoint and ransacked his house with the intent to commit a theft. He's charged with felony murder predicated on aggravated assault with a deadly weapon. Aggravated assault with a deadly weapon just means that he used a gun and he shot at Malik Berry Buchanan. A deadly weapon by law is a firearm. A firearm is a deadly weapon as a matter of law. You'll hear the court tell you that. And finally, the defendant is charged with possession of a firearm during the commission of a felony. He's guilty of that when he unlawfully has on and within arm's reach a handgun during the commission of murder, felony murder, armed robbery, burglary, or aggravated assault with a deadly weapon. the felonies that he's charged with in this indictment. The court is going to tell you to base your verdict on the evidence. The court will never tell you to go looking for doubt. The court has told you and will continue to tell you that your job is to seek the truth. So what is evidence? It is the means by which any fact that is put in issue is established or disproved. It can be direct, meaning eyewitness testimony, or it can be circumstantial, which is proof of one or more facts that tend to prove or disprove some other fact by inference. So some of you got asked a question by me during voir dire. You got kids, they ever get to you competing accounts of the same story? You weren't there, how do you know who to believe? A lot of you gave the answer, well, you get a number of things. You look at the evidence, the facts surrounding what's going on, my experience. I sort of pressed you a little bit, you look at your demeanor, you listen to what makes sense. And you were like, yeah. One thing that I want you to remember, you may not be able to take those cell phones or computers or searching devices back there, but you got your common sense and you have your reason. And never once will the judge tell you to check it at the door. You are supposed to take that right back there with you when you look at this evidence and consider it, and make your decisions based on your common sense, your reasoning, the evidence in the law as the court gives it to you. So just to give you an example, just an illustration of what reasonable doubt and evidence looks like. So you all have been patiently listening to this evidence and listening to us for the last week or so, and I thank you for that. But say at the end of today, you decide, whew, it's over, Judge McBurney has let us go for the day. I'm gonna go home. I don't have to listen to Peanut Butter Miss Love anymore. I don't have to listen to Miss Oakland, Miss President, her co-counsel. Whew, I'm gonna go relax. You step outside the courthouse and you notice a chill in the air. Now this weather has been getting crazy. This morning I asked Alexa, what's the weather? It's 61 degrees. Today, expect a high of 92. I don't even know how that happens. But say you walk outside this courthouse and you feel a familiar, crisp chill in the air. It was 72 degrees when you came in, but the temperature is dropped. You notice that those previously blue skies are now kind of gray. And you feel in your bones that thing that lets you know it's feeling like snow. You don't think anything of it. You get in your car, turn it on, you drive home. You get home. On the way there, you hear the radio weather person saying 60% chance of snow. There's a huge snow front coming through this evening. You don't see any snow, but you hear people talking about it, and you feel the signs of it. You get home, you pour yourself a glass of wine, you turn on your TV, and you got another announcer saying, that snow front is coming through. It's gonna hit us tonight. So you go to bed. You wake up the next morning and your girlfriend calls you and she says, oh my goodness, did you see it coming down? It was beautiful. Direct evidence. You go outside and look. Your entire neighborhood is blanketed in white. You didn't see it snow. But do you have any reasonable doubt that it did? Now, is it possible that a movie crew came and showered your entire neighborhood in a blanket of white? Anything's possible, but is it a reasonable deduction based on all the circumstantial evidence that you had up until that point where you saw the snow for yourself? you really have no reasonable doubt that it snowed in your neighborhood. And the evidence, both that eyewitness evidence and that circumstantial evidence, is what told you that it did. I have a niece who is my heart, who is now 23 in the vein of my existence on very many days. But she has been my heart from birth. And at 6 years old, she was diagnosed with type 1 diabetes, which means that her 6-year-old little self couldn't have the very thing kids love most, sweets. So when I keep her, it's my job, and she was little, and she's grown now. But it was my job to make sure she didn't get too many sweets so that her sugar levels didn't skyrocket and her mother come from out her. So Jordan stayed with me most weekends and summers. One particular occasion where she was staying with me, I'm inside the house with her, it's just me and her. And I know that I keep sweets in the house, but I try to keep them at that time out of her reach. So I had a canister, oddly enough, we're talking about peanut butters. I had a canister of peanut butter cookies that I kept pushed back on the counter. I step outside. I know where that canister was when I left the kitchen. I step outside in the garage. I can't be out there 15, 20 minutes. But I come back inside and I'm walking to the sink and I see at the corner of my eye, the canister looks like out of place. And then I look a little bit closer and I see crumbs on the counter. And I asked Jordan, did you get any peanut butter cookies? Because it's important to know, because any little bit is gonna run her sugar levels up. But she's sick, so she's not gonna be entirely honest with me, no ma'am. And I'm looking, I'm like, what the rats are, what's going on? And I'm like, Jordan, are you sure you're not gonna get in trouble? Auntie just needs to know. No ma'am, she's looking eyes wide. I said, Jordan, come here. I lay down, open your mouth. Breathe. Peanut butter all over her breath. I didn't see my niece eat those peanut butter cookies, but I know she did. I have no reasonable doubt that she did. And once she was caught, I'm sorry. That wasn't the point. Now, is it possible that some mechanism of her biology makes her breath smell like peanut butter on this one particular occasion, and that some invisible rodent came and pulled the crumbs out and moved the jar? I don't know, maybe, but it's not likely. I have no reasonable doubt that my beloved niece ate them peanut butter cookies. Evidence, the court will tell you, consists of exhibits. That admonition that Tony Montiel had Dr. Kristen Canada look at. Those photographs that she looked at. That video of her looking at them. That latent print lifted from the scene of Malik Berry Buchanan's murder the night of March 16, 2007. The court will tell you that evidence consists of witnesses' testimony. And there were a lot of them. And Ms. Oka will go into more detail with you about what they say and how they let you know he's guilty. But you also have your collective memories and your notes. Refer to them and remember and use your common sense. The court will tell you about the credibility of the witnesses. You alone decide that. So you looking at these witnesses testifying, you decide who you believe. You have the evidence. You saw Dr. Canada on the stand. She didn't look like somebody with a vendetta. She looked like a thoughtful, tearful, sincere person who does not want to just go and put yet another Black man in jail. She wants the person who killed her unborn child's father held accountable. So she didn't come in here ranting and raving and pointing at the first person she thought might be the one that did it. As a matter of fact, she gave no indication until she stood up and actually saw those eyes, the ones that haunted her nightmare here in this courtroom. Even then, she didn't tell y'all. She just started crying. You decide. Is she credible? The court will tell you that the testimony of a single witness is sufficient to prove a fact. You need no corroboration. So if you believed her, that's all you needed. You didn't have to bring you anything else. Even if we had never found a fingerprint, even if we had nothing else, if you believed her and she was on that stand for a long time so you could get a chance to see and hear her and have her cross-examined and scrutinized so you could decide whether you believe her. Because while we may have talked to her a number of times, that was your first time meeting her. So you needed to get to know her. And thank you all, each and every one of you, for sitting, listening, and paying attention to what she had to say. Because her testimony alone, if you believed her, you didn't need anything else. The court will tell you that. The court is going to charge you on identification. The court is going to charge you that you decide whether or not an identification has been made by looking at the witness's opportunity to view the perpetrator. How high Dr. Kennedy's degree of attention was as she saw that person that she didn't know walk out of her unborn child's father's home and walk towards her as she waited for him. Her attention was high as she saw him lift that gun. Her attention was high as she saw him pull that trigger. But when he did, her attention left him and went to her fallen boyfriend on the ground.
So you asked that I let you know. This is about 5 minutes if you want to stick with your schedule.
Thank you, Judge.
You're welcome.
Whether or not that identification was influenced by any other factors, Dr. Kennedy didn't know that this defendant's fingerprint was the one on that screen. There has been no evidence, there is no evidence to the contrary. She didn't know that number one was Jerry Hodges. Number two was the person whose number 8 finger was on the screen that came from Malik Barry Buchanan's window. Out of all the people in the world, his fingerprint, her identification. That means he's guilty. She never identified anybody else as the shooter. The defense wanted you to believe by inference that the detective from 2007, Max, that when he wrote down the Buchanans and my eyewitness, somehow they want you to believe that that would have been Dr. Kennedy. Somehow they want you to then believe, with nothing else, that she misidentified someone. That didn't happen. There's no evidence of that. Dr. Kennedy saw this defendant's face constantly in her nightmares. She remembered it even this past week. He didn't live there. He had no permission to be there, and his fingerprint was there. You know, there's a difference between description and recognition. And on cross-examination, the defendant attempted to bring up things that Dr. Canada had said in an effort to disprove Dr. Canada's identification. That was their entire opening. It's ridiculous. They left out of their opening any information about fingerprint, but that's okay. They don't have to prove anything. But they wanted you to believe it is utterly ridiculous that she would remember and identify this defendant who's the shooter 15 years later. But is it a description that matters, or is it the ability to recognize someone? Because description does not equal recognition. Take a look at those eyes. Can you tell me, what's his hair like, that person? Does he have any facial hair, beards, sideburns? What kind of clothing was he wearing? Jacket, tie? What's behind it? Do you not recognize who that is and what that's a picture of? The court is going to charge you on parties to a crime. And I'll break it down as an example like this. 4 people decide to rob a bank. The court will tell you that any person who directly commits a crime, intentionally helps in a crime, are all parties to a crime. So 4 different people decide to rob a bank. And I'm going to try and push my opening close along, because Ms. Oldham has the bulk of what needs to be said, and we only get a certain amount of time to talk to. So I can be long-winded, I'm going to try to make it short. One person is driving the getaway car. One person is standing as a lookout. One person is holding a gun on the guard, and one person, the 4th person, is collecting the money. Now, after collecting all the money collector runs out of the bank. The gunman is right behind him, but gets jumping. And just as he leaves and goes out the door, he turns around and fires a shot and shoots one of the guards. The guard dies. And then the lookout, the gunman, the money collector, they all get away. So who's guilty of murder? All 4 of them. Because any party to a crime may be prosecuted for that crime, even if another party has not been prosecuted or convicted. So you don't have to worry about what happens to the other 2. They'll get their day, hopefully and prayerfully. It's this defendant's day in court that we're here for. The court will tell you that the state's burden is to prove the defendant guilty beyond a reasonable doubt, not to a mathematical certainty. During our opening, Ms. Krimovic said the state's burden is real high. And sometimes people like to put numbers to it. But beyond a reasonable doubt doesn't mean the state answered all my questions. It's just that you now have an abiding belief that the defendant committed this crime. I believe he did it. The court will tell you about the statute of limitations. In Georgia, there's statute of limitations on every crime except for murder. But that statute of limitation tolls, like it doesn't start to run until we know who did it. And so in 2018, when the defendant's fingerprint came back as a match to that on that window screen, that's when the statute of limitations starts to run. That's when the state knew that this defendant was Malik Berry Buchanan's murderer. We don't have to prove motive. We don't have to prove motive. That's another thing like premeditation. It's there for your consideration if you find one, but we don't have to prove it. I submit he didn't want any witnesses left behind. He didn't cover their faces. You were chosen for a reason. And the 3rd duty that I spoke with you about is to deliberate. Never will you hear the court say, go look for some doubt. Not, I believe he did it, but where is that gun? Where are the other 2? Why did it take so long? Anything after that, but is irrelevant. Because if you kept your own, you presumed that he was innocent. And if you're not thinking, I believe he did it, it's only because the evidence took you there. And that is all that the law requires. And if you believe he did it, find him guilty. If you don't like the police or the job that they did, do not hold it against Barry Buchanan. If you don't like me or the job that the state did, my boss, Ms. Oakham's boss, she was elected by you all. Find T. Willis. Go write her and tell her, I don't like their prosecutors, but don't hold that against this family. If someone stops participating, bring it to the attention of the court. If you want to see or hear a piece of evidence that was admitted at trial, just ask, but deliberate. The fact that the defendant came in with the presumption of innocence does not mean he is actually innocent. It just means he's entitled to have the state prove his case beyond a reasonable doubt. Render a verdict that speaks the truth. One shot is all it took to end Barry Buchanan's life. One shot is all the chances we have to hold this defendant accountable for that death. We didn't stop at one witnesses because we only do have one shot. We don't get a second chance. You don't get to go out, talk to folks, do research, come back, change your mind, and have a do-over. One chance is all we got. One shot. So I ask you to do what you were chosen to do. Consider the evidence. Follow the law that the court will give to you. Use your common sense and reasoning. Find the truth. Speak the truth. And render a verdict that speaks the only truth. This defendant is guilty of each and every crime in this indictment. He knows that. And now you do too. Thank you.
Thank you, Ms. Love. We are at noon. In fact, the clock just turned to noon. So we're going to take our lunch break. When we get back, Ms. Primovic or Ms. Feely will have an opportunity to give the defense closing. And when that attorney's done, then Ms. Oakham can give the state's rebuttal. During your lunch break, please don't talk about the case. Yes, the evidence is closed, but you haven't heard both sides of the argument. And just as importantly, you have not yet received the law that I need to give you. So we'll reconvene at 1, try to be back at 1 o'clock. And we'll make sure Ms. Primovic or Ms. Feely is ready to go at 1. We'll keep pressing on. You will get the case this afternoon to begin your deliberations, just so you can plan for today, tomorrow. Once the case is in the jury's hands and you begin your deliberations, we're on your clock. So if you decide you're going to go a little bit late today and want to stay past 5, we stay as late as you want to stay collectively, up to a point, because we've got to make sure we can get you back to your cars at those parking lots. But we can certainly stay past 5. And then if you don't finish today, we'll start tomorrow at the time you all collectively agree you're going to come in, whether that's 8:30 or 10 or whenever it might be. So just know that you do need to deliberate, but those hours of deliberation are much more flexible based on what the group's schedule is. Any logistical questions before you go get a great lunch? All right. See everyone at 1 o'clock. Don't talk about the case. Thank you. All right, you all can be seated. Ms. Love, Ms. Oakham, anything from the state?
I would just ask her, how many minutes do I have left?
You will have, assuming you need the full 2 hours, 60 plus 25, 85 minutes.
Thank you.
You're welcome. That's plenty of time. And of course, you all have 120 minutes if you need them. Ms. Primovic, anything before we break for lunch? All right, let's all be back a little before 1. We'll be in position and get going as close to 1 as we can. Thank you. Let's put up the little lunch break sign, and then I need to talk to you for a second. How are you? Good to see you.
Who are your lunch ladies?
Several judges got stuck. They didn't know you had to use your card in the elevator.
This guy said.
Pretty embarrassing.
Jacob is stuck in the elevator. I said, oh my God.
Just put,
Guess what she was doing, Judge? She was sitting on the floor.
she sent me an email. I'm like, hey, what's your little?
I did this morning.
So not a car,
On the inside.
On the inside.
Yeah.
Outside the inside.
You used to, but now this weekend they put the stuff in, so you need a card to get it, and then once you're in, you gotta do a card, right?
So do I?
Yeah, I got all of this morning.
That says Judy.
You were stuck in there, too. It was moving. Yeah, Judge Ingram, she was on her way east, and she didn't know.
I saw the thing, but I was like, okay, why is it back on?
Hey, how you doing? I'm good. How are you? I'm cool. I just came to leave my phone. I'm back.
Trying to keep all my parents. I don't know, she said my eyes was good.
You tired?
No, I was fine. Here. And then all of a sudden I just started feeling nauseous. And
Oh.
like completely nauseous. And you know what? No, there's this medicine that I have to take. So I could. I took it on an empty stomach. The thyroid medicine you're supposed to, but take the test for skin stuff, and you're not supposed to. I took it on an empty stomach. It made it, I don't know. Jamaica got us cursing me and Marilyn COVID, so. Cause they're both sick and.
Yeah, the 88.
Yes.
I tried.
Three, we got 3 that are out.
They were supposed to do it, and they were gone in contact with each other, probably but trying not to, and our office was right up.
But you were the one that's been over there, you probably got some crazy, like,
So please.
whatever
we
against
need to
COVID.
keep it.
So,
Said to keep it.
she probably got some barrier
Oh, wait.
against COVID because she got babies.
Oh,
And she
oh,
would
wait.
never catch it. She's the one sitting right next door to the girl with COVID. Like literally, I'm way over apart,
They
a
need
whole
to
other
stay
area.
away from me.
She probably gave it to me and I'm the one getting sick.
All I know, is y'all need to stay away
I
from
tell
me.
you,
Yeah,
she
okay.
gave it to me and I'm getting
I thought you
sick.
got back to focus to that.
I'm
I
getting
do.
sick.
I won. I mean, 3, but she told that they don't want.
I had never,
We'll see.
I'm so proud. I feel like I'm right road every day. I wrote when I let go. And I wrote when I that's
I'm so shocked.
pregnancy.
And you got this money.
35.
Right.
Yeah.
That's why you learn rights.
Well, then she'll be like, well, you can
I was 5 minutes old.
don't worry about it.
I don't know how that happened.
Yeah. You know. Some people
You take that out. You take all that out, that whole thing. Yeah.
want to talk about. So I'm yeah. She called me yesterday. I said, right. I said the nurses go in that for them. I was like, she's only. Yeah. But they had to put like this yellow, things on it to have one of these. The touch. Yes. Because he loved it, so I said, how did he get out? It's a relationship. And I'm gonna say, right, you make that money. Yeah, it's a that's a work. Get rid of it. Yeah. I said,
One thing I saw you do that was really effective.
oh, yes. Oh, yeah, right.
Yeah.
No.
How can I get you anything?
No, I would like to go back and get my skills, actually.
Where are they and I'll get them?
I don't know where they are, that's the problem.
Where do
I don't
you
know if
find
they're
them?
in the purse.
Or else they'll-
No, I have like a bunch of skills, why would we waste them? No, wait, so eat it later. No, I'm trying not to eat them, I only eat them when I'm trying. Because they're bad for me. Yeah, but if I, that's what I'm saying, I only eat them when I'm trying, because if I'm not on trial, I eat them when I don't need them. Which is why I don't buy them unless I'm in trial. See my cash 22? I love that. So I would just sit down and eat all
They
that.
made me a little sick.
No,
I thought
love
they
it.
would make me feel better, but girl.
So I don't buy them unless I'm in trial because I can justify it. I can justify everything that I do.
Your baby's got it scrumptious.
You too. You probably got to have one. Mine is not, I don't know how that is. I told her, I said, he's probably just had lunch.
I got my lunch there.
Oh, that's so cute. Where you going with it? No. You're actually doctor, doctor. Dennis, I don't consider as a doctor, unless you're getting a tooth pulled. That's when you get to Dennis, you go for cleaning. I was like, that's how they medicine. That's just hard. You don't feel good. No, you don't know my mom, but then the first time she didn't know her right. You feel that deep clean that they'll do, right?
Go back to the third.
She not there, she had to go home because they done it all at once. Awesome.
Go down.
You need to have stuff on your stomach if you're going to take it.
He hasn't gone there.
Oh, God. Today, you see it? I worked at law firm.
Oh, you got it.
I went to the office in Washington.
Did you some daytime sinus now, you know? I went, it's daytime, I took them Friday, so they won't be walking around. I was okay, it was okay Friday. But watch, it might upset your stomach if your stomach's empty.
I took one sip. I thought it would do it. It's too sweet. Sometimes it's way more. Did you see your second chair? Oh, yeah, I did. When you read that, I was like, oh, I just kept talking. Yeah, he looked like he was smooth. It was like, he was smooth. He don't really have to. That's good. But that's like, what is he?
I would have a few questions by the time I was at that. I would have a few questions.
I was, it was smooth. And then I just walked away.
I don't. 76 years I had second church always.
That's how we. Sometimes we have a second. But I just want to make a lot of sense.
Yeah. People need it. The biggest cheerleader in my first moments. It's like, no. Extreme, yes, extreme, peace, extreme words. He was like,
Colonel's makes me hire to work.
Did he say 1 o'clock or 1:30?
1 o'clock first.
So very good.
He said,
No, he said 1 o'clock.
So why you got?
it's 1 o'clock, yes. I don't know. I'm ready to. I think that's just what it says. That's the same thing.
no, because it's nothing.
Friday.
He. So, yeah, so we made it.
Yeah. Yes.
Yeah.
What? I would buy you a shot and see.
So we're gonna get there. We're gonna buy. Skittles. What do you call it? Skittles? Skittles banners. That's what we do. It's not really going on. Well, let's look on the page, strengths and we age it. It's great age it. Yeah. Rivers. Insane. Oh, yeah, ma'am. I said, how did y'all? Okay. She said, I know, but I know she was also like. So I know she was also. But I just, you know, I'm trying okay, you're right, I should have said. Really, you said it's 5 minutes away. And all the books. Sir, it's a year before. Oh. That is interesting. You're the one who's cops.
No, he told us one.
I think he has to report at 12:30, that's what he said, remember? No, you can see it's not really here.
She's looking like model straight ahead. I was like some because the camera is catching me from this angle and this angle. It's like she's been through this before. So here it is, she does. So her picture is invaded. That would be to me.
You know.
Oh, no, we're taking first.
I got a whole six pack. They're hot, so you have to get ice.
Yeah, but that's probably better.
Is it the hot ones?
No, we have the
Don't have.
non-alcoholic soft drink, that's the key to it.
I'm gonna pop this thing over here.
Cheers. Thank you. You're welcome.
Oh, Jesus.
Frank, I would love it though.
To say.
Ooh, that is sweet.
Yeah, I need to know when you became converts. Because I've been here for
Pardon me?
11 years.
So again,
I wanna know when you became.
COVID.
Oh.
When, I mean, it started, but your case was my first one. And we got new laptops and then we didn't use them. We didn't have those kind of things before.
Are you?
Sure. Need you.
Miss Love, ma'am.
She's like the ginger beer fairy.
I'm so excited about it. I mean, I feel your pain from last week.
Oh.
It was. Oh, you got me good. I went looking for some, but I didn't even see it.
You got one.
We're done with it. We're muted.
Oh.
That's right, that's your spirit. It's a burden. Cucumber.
Oh, yeah.
You don't know. That's what you're talking about. Everything good? You want to roll it back. I'm good. Yeah.
It's like they both put it on that one.
Yeah.
I don't want to cut into your skills.
That's a bad nurse. But that's here.
How do you eat Skittles? That's okay.
No. It's been good. Oh, yeah, we don't have nurse. No, let me see.
Except for Skittles, we all get GI system. We don't think about it. This was like.
I don't know why that said 1:30.
Yeah, I'm supposed to put yours on.
We have no deputies though. There they are. Uh-oh. Yikes. Service levels just went down. Deputy Gordon, can you please give this to Ms. O'Connor? O'Connor, if you could give one copy to the defense. That is the final version of the jury charge. Do we have all? Great, if we can bring Mr. Hodges out. Yeah, you actually need to do something. It's not just drink water in the corner. Is that his radio? That's yours. Oh, should you leave it in here? Where did Dunn go? She was just here for 2 seconds. What are they? Oh, whatever courtroom she's in. Okay. Yeah, because Judge Ingram's fell apart because those lawyers got COVID. Who knows? They work in mysterious ways on the 7th floor. All right, Ms. Rivers, are you ready? We are back on the record in State versus Hodges. Mr. Hodges is here with his lawyers. The prosecutors are here. I've been told our jurors are back from their lunch. Ms. Primovic, will you be giving the closing?
Yes, sir.
Are you ready?
I am.
Great. Let's bring the jurors in, please. I will get a verdict form for you all to look at when we're done with closings.
Come in, ladies and gentlemen, if you fix cell phones, you're outside of fire, please. Fix phone.
We gave this. Thank you, Deputy Gordon. Welcome back, ladies and gentlemen. Everyone else can be seated. Hope it was another good lunch in downtown Atlanta. We heard from Ms. Love, the first part of the state's closing argument, which brings us now to the defense closing argument. Reminder, there's no burden on the defense, so there may be no closing, although Ms. Primovic has hinted to me that she will be making a closing on behalf of the defense. Is that true?
That is true.
Now is time.
The state's theory to convict hearing officers is twofold. Memory improves with time. And this case is like a movie with dreams and nightmares. That's the state's theory. When you boil it all down. And I'm going to go into all of this in detail to show you how the state wants you to think those types of things. We talked about beyond a reasonable doubt in opening. The judge gave you a pre-charge. The state talked about it. I talked about it in opening. But what is reasonable doubt? And I'm going to go over all those things and give you examples.
And it's basically bits and pieces of the state's entire case. The state said already on their closing, don't look for doubt. What does that mean? If there's doubt, just ignore it? Is that what that means? Because that's not the law. So when the state's saying don't look for doubt, I don't really understand. You need to look for everything. Truth, doubt, credibility issues, what's reasonable and what's not reasonable. And I believe I said in my opening that this was not reasonable. The state asked you to not leave your common sense at the door, to not leave your life experiences. Please bring your life experiences. We've all lived a life. Please do. And when they say don't look for doubt, what does that mean? Because that's not the law. The statement she typed word for word for word for word, she typed it. 5 hours after the shooting. And what did she say about what happened? And this is important because 12 years later, when she makes an identification of Jerry Hodges, her story was different. That's why this is important. This isn't nitpicking. This isn't red herrings. I gotta try to guess everything the state's gonna say after me. This is legitimate memory changing. Because why? Memory does not get better with time. We all know that. We don't need an expert to come in here and tell us about our memories. And what did she say? 3 young boys ran out of the front door and Malik ran out behind them. 5 hours, her words. She sat and typed it. Her words. The first 2 boys kept running, but the dark boys stopped by the bush and shot Malik in the chest. I showed her the statement, Defense Exhibit 1. You got this from the defense, not the state, by the way, who didn't even mention that this statement existed in her opening, but we'll get to that. I asked her, ma'am, doctor, please show me where you mentioned eyes. He looked right at her. Because why? The state wants you to think memory gets better. The night description of the shooter. I asked her, she said short, 5'7", very, very dark skin, flash would look like gold teeth, short dry gloves. No mention of eyes, none. But the eyes get very important when she testified. Why? Because she was having nightmares and dreams. This is like a movie. Just like a Lifetime movie. It's not. This isn't real life what they're trying for you to know, for what you to think. Your memory does not get better. And she said this hours after the shooting. Not only did she say it, she typed it. No mention of her night of the statement from the state in her opening, like I said, and how come? It did not fit in their formula of Jerry's guilt. This statement doesn't fit with what they want you to know. Doesn't fit. But it happened. And we have it from 2007. Detective Zimbrick talked to us about memory. He was the last detective to testify, the last person to testify. He said that they can change sometimes. You talk to him a couple days later, the story can change a little bit. You talk to him a couple weeks later, the story can change a little bit. Miss Feely asked her, how about in 12 years? Yeah, not so much. We're talking about 12 years. Ms. Loud brought us in her opening or close, a picture of George Washington's eyes. She was like, even though you can see the eyes, we all know what it is.
We've seen the dollar bill before. We have seen it hundreds of thousands of times. We have not seen it in the dark, not in mere seconds, and not only one time. We see dollar bills all the time. The situation we have is she witnessed someone in the dark with stress backing up her car in mere seconds. So please, when the state brings you in the eyes of George Washington, just say spare me, because it doesn't apply to these facts. Is it a real dollar? Don't know that much anxiety either. Detective Mathis, she typed her statement herself. That took a little bit to get that out, right? Again, this has been years ago, 15 years ago, since Detective Mathis took this. 15 years. Refreshed his memory. He's like, that's right. I don't type very well. She's a typer. She could do it fast. We talked about it. And then she typed up her statement, and I asked her questions. So when the state comes up here and says she didn't give all the details, she forgot to say something, someone else, the typist, must have left it out. She was the typist. And she never mentioned eyes. And she never mentioned two guys, two boys, and then one after. We'll get to her statement from the 19th. Detective Mathis, again, two young boys got arrested the next day or the day after, burglarizing the same apartment complex. He did not do a lineup with these two gentlemen, Irving and David. Memory said it's hard to get juvenile pictures, there was red tape, we tried yearbooks. The fact of the matter is they had two young boys that fit a description that she gave to African-American boys arrested around the same time in the same complex, and no one gave her a lineup to look at. I guess the state's going to get up because they had a fingerprint expert and said, you know what, Irving and Bailey, you know, their fingerprints didn't match. So we don't want to put them. There were 3 to 4 robbers that night. Wouldn't it be nice to know if one of these young men was involved? The shell casing in the laundry room, we learned from him, because he was a detective on the scene. He was out on the scene. They collected a shell casing in the laundry room. It's in evidence. We're going to go over the pictures. Did it shoot through the laundry room that had the, what did that shell casing have? I find the shell casing to be very much like the fingerprint. When did the shell casing get it? It's the same. This is a murder investigation. This family lost a 23-year-old son. Dr. Canada lost the father of her child. This young man in the courtroom lost his father. And you can't put a lineup with two boys that match the description in a lineup. This is called lack of evidence. And you can all use that in fact. That's more reasonable doubt. The lack of evidence. Ooh, 2007, I don't care. We're acting like it was Little House on the Prairie. Her memories of the shooting. And I separated them out as best as I could by things that were important. And the black matches the black, blue, the blue, the green, the green. The night of, all three boys ran out. And why is this important again? 12 years later, after she did her photographic lineup in Chicago, she said 2 boys ran out. Night of, Malik followed them. right? 3 boys ran out, Malik followed after him. Nope. Nope. That's not what happened. My memory's changed. And let me tell you, the state is right about more. Dr. Canada's not here in some vengeance. She's not out to get anything. It's called memory. And it doesn't matter if you're a doctor, Albert Einstein, George Washington Carver Jr., your memory does not get better. And I am attacking her memory. She went off and is doing great things. She went back to school, became a doctor, but her memory is like all of our memories. It doesn't get better. Malik followed them the day that she did her lineup and hearing trial. Malik and the dartboard was shoulder to shoulder getting out of the door. Now those are 2 big memory differences. That's huge. That's not he had a dark black shirt on or he had a dark blue shirt. This is how the boys ran out of the apartment. Either 3 of them ran out, or 2 ran out, and him and Malik, the dark boy who became the shooter to her, were partying to get out. Dark boy stopped by the bush and shot Malik, night up. Malik ran in front of the shooter, who slowly walked down the stairs, looked at me in the eyes, and shot him. And he didn't run off, he walked. This is the same day that she identified Jerry as a shooter. Dark boy, gold tee, short dreads. Dark boy with short dreads the next day. No eyes were mentioned. I gave her her statement, and I asked her, please tell me, can you talk to me about those eyes? The state, I expect, will make a big deal of, they already did, with Washington's eyes. Not there. Yes, she said she had dreams, she had nightmares. Absolutely, you would have nightmares. Awful. Thank God she went to the therapy, she said, stopped the dreams and nightmares in 2008, and they started again. Dreams, nightmares is not our memories. And we don't need to have a dream memory coach to get in here, an expert, to know that what we all know in real life. And if the state wants to hang their case on dreams and memory, let them. That's a reasonable doubt right off the rip. And they are using dreams and memories as their tool. She picked Jerry out of the lineup and then in court. Let's go over the lineup of the time. 12 years. And I know you're tired of me. I'm almost tired of saying it. If this young man wasn't here fighting with murder charges, but he is. In 12 years. The first time she was given a lineup. And she comes with that story that I just presented. How can you trust her memory to get an identity? Let's go over what 12 years is, right? 626 weeks, 144 months. First day of kindergarten, raise your kid, all the people you see. She raises her child, all the people you see, until your kid graduates high school. This is literally a child's education, is how long 12 years is. In 2007, this is what was big. Biggest thing in 2007, the iPhone started. This 12 years, all of this. Dr. Kennedy lived through all of this and all of her experiences, going back to college, going to med school, raising her children in 12 years. Basically lived through the iPhone alone. To give you some context of time, the music that's changed, politics that's changed. 12 years. Let's go to the photographic lineup. She gets a phone call, Detective Zimmerink, we heard him testify here. I don't know if I said there's fingerprints, we found somebody, and there's fingerprints, I don't really recall. She had to have known there was a reason that 12 years later, they're making a call for her for a reason. They're not gonna send her 6 photographic lineups just because, I don't know, it's 2019, we felt like. She had to know she's a smart woman. She completed med school. Almost as importantly, she knew how to run this little thing with the circles and the monitor. She knew there was a reason. She knew there was someone in here. Just Feely asked Detective Hambrick, picking out somebody in a lineup 12 years later, is that something? He goes, it's truly remarkable. And I want to show you this lineup. You'll have this back. And you saw her video. She looked at number 1. I want you to just check out the darkness. Number 2. Number 3. Who's the darkest in the room? Keep the darkest in the room up. Number 4. Number 5. Number 6. And after she did this photographic lineup, it's the first time we heard about what? From the darkest person in the lineup, which is what she has consistently said. Obviously, there's only one dark African American male in this world. That's what the state wants you to believe. Look at his eyes in this picture. Now her memory remembers eyes. Her memory made up eyes. It happens. It happens to all of us. She picked the darkest male in the lineup, and you heard about eyes. You'll get this. You can review it yourself. That's what happens. Again, after she did the lineup, she did her statement. And this is the first time that we heard this new version of facts of 2 boys, Malik and the dark guy who became the shooter, fighting to get out of the door. Malik ran ahead, he just strolled out, looked right at me. I shot him. Shooter just rolled right on. First time. But she saw the eyes of the darkest male in the lineup. Because she knew that the shooter that the police thought was in that lineup. So you're going to pick the memory you remember most, dark skin. That's those eyes in that picture. So the memory goes there. All that is a doubt in which you can place a reason. And you don't even have to look for it. They presented it to you. Officer, the arresting officer column. Arrested Jerry 3.5 years ago. 3.5 years. You saw pictures from the body cam the state showed you Friday. Sunny afternoon. It couldn't have been any more bright. Blue sky, standing right in front of him, looking at him, we could see him, looking at his ID on his computer. Sunny afternoon. Probably spent many minutes with him talking with the men
in the car, talking to him, maybe even hours, because he drove him to see Detective Hamrick. He chased him as he ran from a murder warrant. Saw him again, we saw that picture. And what happened, you think? Everyone take your masks off. Officer Holland, do you see the man you arrested? He's not in this court. He had the most perfect conditions I've been seeing. The most perfect conditions. 3.5 years later, and could not identify. Now I expect the state to get up to say, you heard him, he arrested thousands. How's he going to remember justice? Well, I see the same thing on Dr. Canada. She's seen thousands of people since then. In college, living life, raising her sons around other young boys. She's seen thousands of people too. He didn't. Because memory and identification does not get better with time. Identification law key points. Ms. Law went over this at the beginning, and hers. Opportunity to view the shooter. There was almost no light. Almost no light. Ever. Pictures to show you. We will get these. Do you see any light poles? We saw one picture of a light pole, and I'm about to show that to you. There's no light out there. That was from a flash and lighting, crime scene lighting. Look over here, where there's no flash or crime scene. Look how dark that is. We're talking bang, bang, out the door. Done. She's also reversing her car to move up the getting. Bang, bang, bang. Opportunity to view the shooter, almost nil. I'm sure some of y'all take your trash out at night. You roll your little cart around. And you see people you know. You know their mannerisms, you know their glasses, you know how tall or skinny they are, you kind of know their voices. Like, hi, Michael. Hey, Marilyn. And then you have a new neighbor. And you got kind of lights out there, kind of not. And you have no idea. You hope it's the new neighbor. What if your new neighbor that you can't really see, but you know is tall or thin, male or female, maybe black or white, depending on the lighting, starts throwing things at you? The shock of someone throwing things at you is like the shock of her seeing a gun get pulled out and the father of her baby get gunned down in front of her. Her degree of attention. She was reversing her car. It happened quickly. She said they ran out, the shots were fired, ran away, was her first statement. She had no way she could have seen this, but a dark, young, black man. And how do we know people are young? Like my mannerisms and stuff in my neighborhood. I know a skinny, young kid. We all do. Length of time between incident and identifying the shooter, 12 years. Did not ID anyone else. She was never given the chance to ID. She was never given a chance. They never gave her a lineup. What about Dante Welch? Officer Mathis said someone identified Dante Welch. What's all that about? That's a doubt. What's that about? Where's Dante Welch? These were bad. Again, lights needed. Now I want you to really focus when you're back there looking at these photos. Look how dark it was. And if she doesn't know, she doesn't remember, the crime scene tech doesn't remember if that little light was on. But if you have light behind someone, we've all experienced the backlighting, you can't really see people. So if the light was on, it would make it even worse for her to see. There's absolutely no lights. And she was moving her car. And makes an identification 12 years earlier. Facts and circumstances that merely place upon the defendant grave suspicion. The judge is going to give you the law. You're going to get the package back. That merely raises a speculation, conjecture of the defendant's guilt are not sufficient to authorize a conviction. It looks bad. I told you all that in opening. Guess what? We wouldn't be here. The odds were 1 in 6 for her to pick out who the state she wanted. And who did she pick out? The darkest young man in the group. That's who she picked in. 1 in 6. Fingerprints. When did the fingerprints get on the screen? We had testimony from Corey that they lived there for about 4 months. When did the fingerprints get? When did the shell casing get on the scene? In the laundry room. It's the same. We don't know. We don't know if the shell casing is the one who shot Malik. Just like we don't know when the fingerprint got on that screen. Beyond a reasonable doubt. Fingerprint is not DNA science. Confirmation bias is real. You heard her say that. The Madrid bombings, you brought that up. That man's life is still ruined. Be a terrorist out of Madrid and try to live your life. Fingerprints ruined his life. Don't let fingerprints ruin Jared's. Human error happens. You decide what is credible, what is realistic in your life. You decide. Again, we don't know when the fingerprint got there. It's speculated. Once we have the speculated fingerprint, it's 1 in 6 that she's going to pick out the most darkly compacted man out of a lineup of 6. 6 people, not 100, not 20, not even 12, not 100, 6 people. And she picked out the darkest skin. I expect that the state is going to get up and argue to you. Argue to it. The state agrees, obviously, to our reasonable doubt. Because they're not going to get up and say, or maybe they will, right? Well, if you don't think Jerry's the shooter, but he was a party to this crime. He was one of 3 of those boys, or 4. So he's either the shooter, ladies and gentlemen, beyond a reasonable doubt, or he's not. So if they get up there with this party to the crime stuff, think to yourself, why aren't they just saying what they, he's the shooter? Because they know they don't have enough. That in and of itself is a doubt. If someone is going to get up and argue, well, if you don't believe that, then believe this. He's just I expect them to do that. Expect. Levels of proof. I believe I stated in my opening, let's be realistic, right? I'm asking you to be realistic. You wouldn't be here if it didn't look bad. If you think he did it, but I don't think the identification is good. That's a doubt which you can put. You think, maybe he did it. Not beyond reason. If you think, yeah, maybe he did it. When did that fingerprint? And it's the fingerprint, I don't really think fingerprint science is. The identification. There, if you say, maybe he did it, that identification is so. It's a 1 in 6 crapshoot. Ladies and gentlemen, it's not maybe he did it. Kinda did it. It's beyond reasonable doubt. And that's a hard standard. That's not a standard that me and you, we live by, right? We live by, yeah, maybe he did it. She probably did that. This is beyond the reasonable doubt. That's why it's jury duty. It's tough. You might disagree with the law, left, right, in between. But you told us you would follow the law. So I agree. They did not prove beyond a reasonable doubt that he shot and killed Malik or was a part of this, or whatever they're going to argue in their court. Judge is going to give you some more law. You'd be authorized to convict only if the evidence, direct, circumstantial, whatever, excludes all reasonable theories of innocence and proves the guilt of the accused beyond reasonable doubt. How about a theory of innocence if she couldn't see to identify something? How about we don't know when the fingerprint got this? How about eyewitness testimony is awful, and you all know that? You don't live in a vacuum. You see that, you read articles, you live the world. Eyewitness identification is the worst. Judge is going to tell you, after giving consideration to all the facts and circumstances of this case, your mind is wavering, unsettled, and uncertain. That is a doubt. Convicting someone that didn't do it, or that the state didn't prove beyond a reasonable doubt, is not going to find Malik's family and this child justice. It's not. It's just going to be 2 tragedies instead of the horrific tragedy we get. There's so much doubt. And I'm going to sit down very soon and I'm going to think of about 15 things I wish I would have asked. But you listened, you took notes, you heard the testimony. It's not enough. And when you're back there, and you go through it all, in the lack of evidence, in the lack of credibility and realisticness of the identification of everything they have and all the things they don't have, you will find Mr. Hodges not.
Thank you, Ms. Primovic. So come, you ready?
Yes. Defendant did not have to kill. See again, it's very important. He did not have to kill him. You know how we know that? Because he is fellow robbers van. But that's not what he did. That's not what Jerry Hodges did. And that's why we're here. We're here because Jerry Hodges did not have to kill Malik. He did not. He chose to. He decided to. And he did it. And these are all the charges. I'm not going to go through all of them again. We'll talk about them. It's a lot to talk about them in detail. This is what the state has to do. This is our word. The state's word. And we gladly keep that word. But once I said the state rests, we had met that word. Because at that point, the state had proved beyond a reasonable doubt. And the defendant, Jerry Hodges, killed Malik. I want you all to keep that in mind, reasonable, right? Now what do we know? What is the evidence from here, right here? Sat here, with exhibits. They put up multiple witnesses, you heard them. All of it comes from here. Now what I say, know what McBurney says, what Ms. Law says, everything comes from there. What do we know from here? Let's start with Dr. Cannon. What did she say? She came because she had plans with her. Look at the details of the things she remembered, right? Ms. Rubrick said, oh, memory fades, we'll remember things. But think of a traumatic experience, right? It was so bad that she had nightmares about it. It was so bad that she went to therapy about it, that she had seen the face over and over again. That is how bad it was. Let's talk about the little details that she remembered. She remembered he must have had hot wings because she had to do nothing now. And had lips in her, right? Because it was a traumatic experience for her. She remembered everything that happened. She dreamt about it. Get the courage. What else did she remember? She remembered his socks. It was by the car. What else did she remember? She remembered his breath. What did she say? The last breath he took. So she did. She remembered that. Why? Because it was a traumatic experience for her. It was bad enough that she had nightmares about it and she saw something for it. What about the other little details that she remembered? Right? Memory's bad. What about the hand that she saw coming out of the back of the door? And Corey remembered that too. Remember? That's what Corey said. She saw the gun, and that is what drew her attention. And Corey took off running, right? And that's why he couldn't remember anything. Ms. Rubrick goes on and on about how, again, the state has a burden, how she's just Canada picked out the darkest person in the night, right? And so she must have known because she's a doctor that he must have found something. You know, why didn't he still pick out something, right? They must have known that the suspect was in there. And the picture was so dark, so it must be the dark person, that black male. Why didn't Corey gonna do the same thing? Why didn't he just pick out the darkest black male because he knew they were black males? It was a dark one. Hey, let's go with the dark one. He must be him because the officers are coming to talk to me now. But he didn't. Because that's not what happened. So Canada picked out the defendant because it was the defendant that she saw kill the father of the child. Let's talk about what else we know. We know there were at least 3 of them, right? Because 2 ran. And the defendant was the one that shot Malik, right? So you had 2 other co-conspirators. One was probably upstairs, one was behind the door. Curry doesn't know which of who shot Malik, right? Because he knows there was somebody upstairs, he knows there was somebody was coming out the door by Malik, there was somebody behind the door. The apartment was trashed. Right? So they went through it, right? As if, I mean, you would also infer because they were young juveniles, they were looking. So they went through everything. They trashed the apartment, they trashed the rooms, they went to the closets, right? And what did Corey tell you? The only thing we had that was value was the computer and the instruments, the music. They're juveniles, right? That's what everybody remembers, they were young. That's not what they were thinking. That's why they were going through all this. What else do we know? We know from here that Dr. Canada was the one that watched the entire thing. That's the only thing we know. She was the only one that watched the entire thing. Corey saw the gun. Ran, I mean, he was running so fast that he dropped his McDonald's bag, right? That should tell you how fast he left the place. But Dr. Canada stayed. She stayed because that was the father of her one child. What did she tell you? People don't die when they love to have. It just doesn't happen. Because she did not believe that that was going to happen, so she stayed. What else do we know from here? As she saw him, she watched him. She watched him because she could not understand why he wasn't running. Not only does she do that, she picks him out of the lineup. And what did she tell you? When I was called and I was told I was going to look at pictures, my nightmares came back up. And I was seeing the face again. So she said. And what's most important for that lineup, right? If it's the darkest person in the room. Montiel didn't know anything about it. He was like, I'm in Illinois, he asked for help, it happens all the time. So I did it. You watch the video. I'll show you the video again because the video is very important. I want you to watch it again and pay attention to what she was doing. He left. And then she was the one that lied. Now I'll talk about the fingerprints as well. The defendant's fingerprints were matched, well, first by the cook in December 5th of 2018. That's why we have the total. Because the state was not aware of who did it. It was a whodunit until December 5th of 2018. This confirmation bias. So 4 people had confirmation bias. Sam McCook had that said it was the defendant. After Sam McCook is verifier, it's confirmation bias. Rebecca Jackson did the whole thing over again, confirmation bias. And then the 4th person that said it, all 4 confirmation bias, that's ridiculous. And the one case that she was asked about is the most famous case, right? But she didn't come up with any other case. What was different about that is only one, right? But in this particular case, 4 different fingerprint examiners have looked at the same print and nobody deviated that it was the defendant's. So put the picture in the past. This is what children do, juveniles, when they're looking for stuff. And you know anything wasn't, so they just trashed the whole apartment. Again, I talked about statute of limitations. It was told, the reason it was told was just a fancy saying of saying time wasn't counted until we knew the defendant. Until the state of who the defendant was, there was nobody to charge. Now, the defense lawyer said she couldn't see what she saw, right? I want you to keep in mind, you see Dr. Karen, right? Just testified. What was important, she also has a 14-year privilege, so inside defendants. We started to weeks, right? What did she tell me? It took my time. As soon as I got to this picture, we said inside. But I still went through all of the pictures to make sure. You know why she wanted to make sure? Because she has a child. Would be the same age or the same age group. Because the defendant was 16 at the time, the son is 14. She has a son that would be in the defendant's place, right? And so she knew how important it was for her not to make a mistake. Even though I knew it was him, I looked through all of the other photos. And what else did she tell me? What did I pray about? Right? Because she understood the gravity of what she was doing. And she also had a son. That's 14. They'd be the same age group. Whose photo could be any one of those boys, right? Any one of them. And she decided, I'm going to, even though I know it's him, I'm going to look at all of them so I can be sure for myself that I looked at all the pictures and this was the person, this was the guy, this was the person that I saw kill Malik. And I'm sure about it. That's why she did that. That's why it's important. Not because she forgot, not because she wasn't sure, not because she didn't see what she saw, but she understood the gravity of what she was doing. And she didn't want, as she said, the situation was reversed for somebody else to do that. So that's why she took the time and she picked the very last. Not because it was the darkest picture, not because of any of that, but because the defendant shot and killed the father of her child. That's why she picked him out. Not because of any shading or coloring. The biggest thing is why was the defendant's favorite person? I mean, he was 16, so he wasn't a maintenance worker. He didn't live at the apartment complex. What are your fingerprints doing at the point of entry of a burglary, robbery, aggravated assault where somebody gets killed? What are your fingerprints doing there? What? What could they possibly be doing there if you're not murdered? What? Why are they there? Do you live there? No. Do you work there? No. Are you a maintenance guy? No. Why are they there? They are there because you committed a burglary, you committed an armed robbery, you committed an aggravated assault, and you killed the lead. That's why your fingerprints are there. I keep saying this because years of people. He did not have to kill him. He did not. That is the definition of evil, cold-blooded, unnecessary. There was no reason for it. Heck, he's fellow robbers ran. So she said, remember Dr. Hannah, that tries to eat. So I see. That's the definition of evil. You kill somebody for no reason. Right? Because you've already been out with the stuff, you had it in your hands, you're already out. Why would you kill him? What's the point of that? Evil. I want to talk about Detective Max, right? Who was up there. But keep in mind, the last case that Max worked was that case, right? 15 years ago. He was done. And he said that she took his leave. So she meant that it was 24 in the morning. That she had come from the hospital. But he told her to so. And it was 2:24 in the morning, right? First, she gives you multiple, right? She does all what the 911 tells her to do. Then she goes to the hospital. She stays at the hospital. And they tell her that he's dead. Then from there, they take her to homicide. And then she talks to them for a day. Ladies and gentlemen, it's supposed to take a common sense, right? Your life experiences to react and do that, right? Imagine her state. Imagine how she's feeling, what she's doing. And the detective is asking her question and expecting her to write it out as well. Because he can't. Think about that. Right? There's no second she puts two in the morning. She's heartbroken, she's distraught. And she's supposed to type and ask a question and write everything out. How? In what way is that even possible? You also keep in mind that she wasn't questioned again after that. So when they went back and gave her another interview, that was it, one and done. Right? One and done. Nobody asked her again until Detective Zimmer took over the case. I was like, I'm gonna look for this again. Right? Nobody. Just that 2:24 a.m. interview. That's it. And she came from the hospital where they told her he was dead. And she's supposed to write down every single minute detail. Come on. After that trauma, are we supposed to believe that? No, because it's not, it's ridiculous. That's why Detective Zimmer says we go back a couple of days and we talk to them, see if there's anything else. But nobody did that for Dr. Cannon. Nobody did. So talk about this. Officer Hall, right? He said, that's what he said, right? But you also have to remember, so Hall is a patrol officer. He arrests, that's what he does. So he told you. You know, maybe he arrests him, I can't even. It's gotta be, it's locked. He had no vested interest in it. All he knows is that there's murder warrant, that's him taking to homicide. You know who had the vested interest? Dr. Cannon. It was her that it impacted her life for years. She moved away. She went to a different state because of it. She went to Alabama. Right? So she goes to school. She was the one. She was the one. She was the one that it impacted her. She was the one that had a reason to remember. She was the one that this changed the trajectory of her whole life. Now she has a child without a father, and she has to live with that. So it's stuck for her. Not Officer Holland, who arrests most people in the day, right? That's what he does. You know who else remembered? Detective Zimmer. You know why? He's the homicide detective, he's lead. He also has a vested interest because he's looking for the person that killed Malik. So he remembered, right? Not Officer Holland where he said, he just ran. Why is he running? He has a murder warrant. I arrested him and I took him to homicide and that's it. I went on my other day. But you know the people that remember is people that have a vested interest. Dr. Canada and Statute. It's important. The life, expense. Again, we have the burden, we have to prove it. About this life. But what did Detective Martin tell me? We do not manipulate. We do not add anything, we do not change anything. Because we are trained to take pictures and collect evidence of what we see and how the scene was. We don't change anything, so the lights are on. So if the defendant is coming out right at the door, his face is illuminated, and she's right there, right in front. That's the parking spot, right in front of him. And she said the closest the defendant got to her was 10 feet. We walked it, right? Remember? She was sitting there and I walked back. And she saw him. And we're supposed to believe that she's going to remember the person she saw that close with that light. Because why? Because memories change and people forget. No! We all have memories, right? Do you remember your best vacation when you were a 5-year-old? You remember it at 60. Your parents, at the birth of your child, you remember it. Because those are important occasions that mark and they leave an indefinite memory in your head. So you know how you're sitting and a memory just clicks back and you remember everything about it? It's the same thing, right? It's the trauma of it. So it's something she will never forget. I don't care if it's 20 years, I don't care if it's 30, I don't care if it's 40 years. You remember the person that shot your father or your child. You don't forget that. You remember that. What did the Texas Immigrant tell you? I've seen 19 years because if it's important enough to you, you remember. You don't forget. What corroborates Dr. Canada's testimony? The science. Fingerprint examination is not new science, okay? It's been going on for hundreds of years. Everybody uses it, the FBI, the government. You know why? Because we can trust it. Trust about DNA. It's actually better than DNA. Because you know why? Twins can have the same DNA. The twins cannot have the same fingerprints. They can't. In all the years that fingerprints have been going on, nobody in this world has had the same fingerprint as another person. But you can have the same DNA. So you know what? Fingerprints are better than DNA. What else corroborates Dr. Campbell? I was living with his mother at the time, 25, walk up Martin Luther King. What was it? About approximately what Texas Immigrant tell you, 3.5 miles away. There's a MARTA station right there as well. What else did he tell you? Corey Gordon told you, right? What else corroborates Dr. Campbell? The hand that he saw coming out, right? That's what Corey says. I saw the gun, I saw the hand, it was a black pistol. You know, after I saw Lee tell me this, I tried to get the gun away, he didn't do it, so I just turned around and put it. It's gone, right? Dr. Canada remembers that. What did Corey tell you? We're not friends. He knows she's it. We haven't talked about it. Maybe they moved on because Dr. Canada was in a relationship with Malik and not Corey. They lost track. They lost. Yes. Because they were never really friends to start with. Dr. Canada's relationship was with Malik. How did she remember all of that? Because she saw what she saw. What else corroborates? The crowd report. Fortunately, we don't have the 911 call because, as we were told by Ms. Ratner, it was long by 2018 when we figured out that the defendant was a shooter, right? Her report says there are 2 different 911 calls, right? And what did Dr. Canada tell you? I called 911. What did Mr. Gooden tell you? I called 911 as well. So there were 2 different 911 calls. Let's talk a little bit about this Dante Walsh person, right? What did Detective Mathis tell you? I don't remember, it's 15 years ago, but it was Mr. and Mr. Canada came with somebody and said, you know, this person might be it. Well, you know what we know? It could not have been Dr. Canada, it could not have been Mr. Gooden. First of all, Mr. Gooden has said the whole time. But what about Dr. Canada? He saw her, what? He was, do you know who they say? He doesn't know her name. He knows Mr. Canada. He doesn't know this is the fiance or the mother of the child of the victim that's killed. Does he remember that? All he does is puts his witness. Right? How is that possible? It's ridiculous, because he wasn't Dr. Canada and he wasn't Corey Gooden. And what did Mathis tell you? He said, I don't remember the facts, but it was 50 years ago. But all I knew is that whatever they said wasn't good enough, and I was like, no, he's going home. Right? But he took a full statement of Dr. Canada, but then an eyewitness, he's not gonna take a full statement and did Dr. Canada again, right? Because this would be a second statement of hers. But that didn't happen. You know why? Because it was not Dr. Canada. And what did all the detectives tell you? They multiple around the scene, we talk to everybody, and then we investigate what they tell us. And if it's nothing, we just let it go. Because they couldn't possibly have seen what they said they saw. And that's how an investigation is, because it's a murder, it's an apartment complex. People come out of the woodwork saying, I saw this, I saw that. So their duty as police officers, as detectives in the homicide division, is to further investigate whatever you're told. But we know it's not Dr. Canada because there's no other statement from her, and she wasn't the person that was there. It was some random person that he didn't even bother to take the name. He just put as a witness. But his lead eyewitness that he just spoke to 11 minutes ago, that's ridiculous. It was not her. I want to go into this fingerprints. Right? God, very good to tell you, this is how the fingerprint looks, right? That's the picture. Same one, right? Black tabs. Are about the same size, 6 exhibits. 81. Right? This is it, it's bent, right? It sits on the window. I want to show you what's important about this. Ms. Jackson counted the finger, right? She said, from your thumb, 1, 2, 3, 4, 5, 6, 7 fingers. What's important about that? That's it, right? Getting it out of the street. This is your 8th finger. All the 10 months. Freaking you off. But I want to show you what it is. This is it, right? Sit it right there. Sit it right there. And you count your fingers. And it's the 8th finger. Perfect. Right? Getting it out of the window. Why is his 8th finger right there? But sit it in the window. Why? You know the answer is? Because he's the one that took it out of the window. Why else? I mean, it's perfect, right? You hold it how you hold and pull out of the window. That's it. Count the 8th finger. Why else would he do it? If he's not the if he's not the shooter, if he's not the robber, if he's not the burglar, why else? What did Ms. Jackson tell you about fingers? Right? Look at all the steps that had to be gone, not by one person, 4 people. Because she was the 3rd person, and then she had to verify. Don't just forget that unique and permanent, right? It never changes, and it's yours forever. You get to keep it. No matter what you do, you get to keep it. Why else would he be there? What is he doing there? Why is it the perfect position for a burglary? Why? If he's not the one. What time do you get there? But you really ask you to believe that somehow, magically, his fingerprints was where the window screen is destroyed, right? Somehow there are no other fingerprints there. It's just hands where the place of entry is, and it could just been there by some magic. Like we really supposed to go hard on common sense at the door and do that story? Because it's ridiculous. It defies belief. Is that what we're supposed to believe? Just happens to be there. Just happens to be the point of entry. Remember what you talked about? All of the things that had to match. The ridges, the islands, the bifurcations, the minutia, all of the things that had to match. And somehow we're supposed to do this magical fingerprint that belongs to the defendant, just happened to be there at some random time that we don't know about, right before the burglary, right before the murder, right before the armed robbery. And then CST, Isaac St. Martin just happened to get his fingerprint. I'm serious? Really? What is this? It's not even a movie. This is ridiculous. Some about his actions as well. What did Detective Zimbrick tell you? Murder warrant out, told his mom about it. January 16, Officer Holland, routine traffic stop, right? He was like, I'm just gonna check. And what does he do? He gives a fake name first, right? It's like, I am my brother. And what did Officer Holland tell you? So I told him, just keep it up. Tell me, who are you? I don't know what to talk about. And then he goes to search and wonders what happens. There's a murder warrant. What do you say? Hold that guy right there. What does he do? He turns around and hightails it out. And he had to be what? Tased. That's how he was called. Again. That's the screen right up there. That's the point of entry right there. Or somehow to believe because of this fingerprint. Just happened. Show us some random time, right? I mean, we think of all the unfortunate circumstances. Your fingerprint is at the point of entry. You're picked out as the murderer. But it's not you, I mean. It's ridiculous. Again, the lighting is right behind it, where he was standing, what she saw. And there is no extension lens or extension cords. You know why? Because they would have been in the pictures. The wire, right? Because she's walking around the crime scene taking photos. If it was there, you would see the lines and the wires of the extended generator. It's not there because it wasn't there. I want you to pay attention. Both when she looks at the photos and she stops, and then she picks the defendant out. Couple of things important about that video. Before she puts her information down, signs her name and says that week number 3. First of all, the pictures are not in order, right? She went from 1, 2, 3, 4, she got to number 4, and what does the zipper tell you? We do that, just so that I don't think of the numbers and base them think that it's a sequential. So it's picture number 4, but number 3, that she has. So number 1. Number 2, what else do you see about the video? As soon as she got to number 3, she put it to the front. Everything else was going to the side, right? Because she said, ding, 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 that's him. But what else did you notice about the video? She made sure she went through all of the pictures. After she went through all of the pictures, what did she do? She went through all of them again, right? Because what did she tell you? I wanted to make sure. And as you can imagine, she's a mother of a 14-year-old black boy. And she's looking at juvenile black boys. So even though she doesn't say it, we all know, she's thinking, this could be my child. If this is my child that's in this photo array, I want whoever is picking out the picture to make sure that they're picking out the right person. And that's why she takes her time. Right? Even though she knew, as soon as she got to him, ding, 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 that's the kill. That's the person that killed my Malik. But I'm gonna go through everything. I'm gonna do what I'm supposed to do. After she does that, what else? Remember? She picks up the stack again. But he's still to the side because she knows that's him. But I'm gonna go through it again. Just so that I know what I know. What else is important? She prays about it. Right? Everybody has different faiths, whatever you believe, that's fine. But to her, her faith is important. So she's like, this is the person I'm picking, but let me pray about it. She does that. What else does she do after that again? She looks at it again. Even though the first time she went through those pictures, she was like, ding, ding, ding. Number 3 is the shooter. She's a mom. She's a black woman. And so she wants to make sure that if the situation is reversed, whoever's looking at it will give my child the same benefit of doubt. But there's no doubt here, because the first time she came across the defendant's picture, she knew he was a shooter. But she did all of that just so, as a mom, she was clear, she was sure that he was a shooter. This was the picture she picked out. It's him. It's the defendant. It's Gary Hodges. He's the shooter. He's the killer. No mistake. No party to a crime to the shooter. You know who the shooter is? The defendant. Now, I've been telling you that we have to learn in these weeks. They said, as soon as the state rested, we had met it. The defendant was guilty. He knows it. The evidence says it is. It's him. Beyond a reasonable doubt. There is no reasonable doubt. There is no reason why his fingerprints are the point of entry. There's no reason why Dr. Garrett picks him out. You know why? Because he's the shooter. He's the killer. He knows it. No sympathy, no prejudice, right? Because there's a little bit of the time. It doesn't matter. What matters is the Jerry Hodges killed Malik? Yes, he did. So you know what? He's guilty. Now the party to a crime. You know why the red part crime comes in? Not about him being the killer, because he's a killer. This is the armed robbery and to the burglary. Why? Because there were a group of them that did this, right? All three of them went into the house. We know that there are two other people that we don't know about. But that's not what we're here today. About those two other people. Know why we're here? We're here for him. Because he was the one that killed, and he was the one that did the burglary. He was the one that did the armed robbery. Right? The three of them did it. That's where the party to a crime comes in. Not because we're waffling about who the killer is. The killer is him. But it was he and his fellow robbers that went into the house. Well, he was the one that actually broke in, started it, because his fingerprints were at the window screen, right? But the party to a crime comes in for the armed robbery and the burglary. Because different people were doing different things. Remember? It was somebody upstairs rummaging. There was somebody behind the door. There was somebody by the lead. Right? So there are three of them at least that were in there. That's where the party to a crime comes in. All three of them were in cahoots for the burglary, for the robbery. And in fact, all three of them in cahoots for the murder. Because while you're committing a felony and you kill and somebody dies, you know what? You get the murder as well. But he's the shooter. Make no mistakes, he's the shooter. Say it again because he bears repeat. This was a sex system. I mean, they had already made their way out of the apartment with the access. Right? They had the clothes, they had the shoes, they had the camera, they had it all. They were out. Why would he kill me? What was the point of killing me? What was the reason for killing Malik? None. Absolutely none. Doesn't matter if you don't know who the other two are. Or you know who we know? The defendants. What matters is the defendant. What matters is what he did. Not what these other two people are doing. What matters is him. And he's the killer, he's the burglar, and he's the armed robber. Ladies and gentlemen, that's Malik. He was 23 years old. He found out he was about to be. I'm sorry, Mom. How long is that? Right? A lot of things he could have done, we don't know. Why don't we know? Because the defendant killed him. On March 16, 2007. That's what he did. He did. He knows he did. The evidence shows that he did. That's what he did. This was Malik at the end of March 16, 2017. With the face on a slab without the handlers. Autopsy. Autopsy. That was gunshot. It's like the perfect shot, right? One shot hits the heart, goes to the diaphragm, hits everything, and he bleeds out and dies. That's what that was. So he's guilty. He's guilty for the murder. He's guilty for the felony murder, aggravated assault with a deadly weapon. He's guilty for the felony murder, armed robbery. He's guilty for the felony murder, burglary. He's guilty of armed robbery, aggravated assault with a deadly weapon, and burglary. He's guilty of all of it. Possession of a firearm, being the commission of a felony. He is. So I ask that you find me guilty on all counts.
Thank you, Ms. Okem. Ladies and gentlemen, we're going to take a short break because what I'm about to do to you is much less dynamic and interesting than hearing from Ms. Love, Ms. Okam, or Ms. Primovic. I'm going to give you the law that you have to apply to the case, and it's going to be much more of a lecture. So I'm going to ask that you have a physically vigorous break. So when you come back, you're ready to sit and listen for a little bit. The jury charge is not as long as the closings, but it is something that I need to give you and you need to receive so that you have the law that you must apply to the facts as you find them to be. Once we're through with that, into the jury room with the evidence, with the indictment, with the verdict form, with the jury charge, and you will begin your deliberations. So this won't be a very long break. I've got the jury charge, I'm ready to go, but you won't make it through if you don't get a break. So we're going to take that little break and we'll be back 5-6 minutes. Give you the charge and you'll be off and running. Any logistical questions? Enjoy your break. See you in a few minutes. All right, you all can be seated. Ms. Okam, anything from the state before we take a quick break?
No, Judge.
Please, during the break, come admire the verdict form, which I'll leave on Ms. Nelson's desk. And Ms. Primovic, if you or Ms. Feely would do the same, and then we can just get on record when I come back if everyone's okay with the verdict form. Ms. Primovic, anything before we break?
No, you're.
All right, let's be back in about 5 minutes. Thank you. So we're off the record. If you also could, after you're done admiring that and take a break, make sure that if there's any disagreement about exhibits going out, you guys start talking about that. So take the break you need, but then please confer to see if there are any exhibits that you think should not go out.
No, yes. Yeah, okay. So that and so we should count them. Sorry. This does or just does not? I mean, this will go. If it just is page, this and the elements right here. Just this. Yeah. Do you want to stay? So you can put a 49 on that. Put a, yeah, 49 AR. Yeah. Anything. 49 J. So and then go grab something from the sheet. It smells me once. I took one sip and I felt better. They're green. This is not. Okay.
49, are we calling it 49R?
49R.
Oh, you just made it R. Maryland?
I just thought 49 J.
$49J.
Where's you put it?
That's right here.
Yes.
They're not. So that's. Is all to support.
This. That's it, I think. This is the last one. And you can paperclip for the photo. Maybe that was already small on the other. Yeah. You want this? Yeah. 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 Huh? Yes, we did. We did. That you were gone.
Let's bring Mr. Hodges out, please. Got one prosecutor in. Oh, there she goes. Great. Thank you. All right, let's go on the record. Ms. Primovic, did you get a chance to look at the verdict form?
Yes, Your
Any issues?
Honor.
Ms. Ocon?
No issues.
Great, we'll use it. Did the two sides have an opportunity to discuss which exhibits go out with the jury and which don't? Ms. Ocon?
Yes, Judge.
Is there any disagreement?
There isn't any, but we did separate space 49 because the top of it had the atheist hit that had all the times that he was arrested. So we just put out the pictures and the fingerprints and we separated into 49J and 49. Because R repeats and J would be the one that goes back to the jury. It's just his picture with the fingerprints.
J for jury, R for record. As long as the defense is not objecting to that segregation, I think that makes sense. And if everyone else agrees, I just want to know, so it doesn't sound like we'll need to do a whole lot of talking. After I'm done, we'll get our two alternates, I'll instruct them, and then Deputy Gordon ought to be in a position to deliver the evidence, the verdict, the indictment, and the jury charge.
Yeah, they're all in here and ready, Your Honor. The only things that aren't going back is
Autopsy 49R,
67
okay, and defense 1.
defense one.
Okay, excellent. Thank you for doing that. Ms. Ocum, are you ready for the jury?
Yes, Judge.
Ms. Primovic?
Yes, sir.
All right, let's bring him in, please. Whoa. Where'd you find ginger beer? And is that street legal?
Yes.
Okay.
Right, street legal, yeah. Someone brought it for me, it worked wonders, actually.
Good.
Stronger than real.
Sounds like it.
It is, but yes, it's open must be mixed.
All right, juror.
I'm a sugar.
Hey, whatever it takes. Thank you, Deputy Gordon. Everyone can be seated. Welcome back. I am about to give you the jury charge in this case. A couple things to tell you about it. First, probably most important, you'll have this document with you during your deliberations. So there is some legalese in here, about that in a moment. But what I will be reading will be up on the screen. They'll be about verbatim. But what is on the screen is from this document, which you will be able to consult. So feel free to take notes, but if I'm rattling off the elements of felony murder and like, wait, I didn't get those words, you'll have this document. And if you need extra copies, we can get you extra copies. Second thing about the legalese, there are certain legal concepts that I am required to define using words that you would not ordinarily use if you're just having a conversation with friends, family, colleagues, unless you happen to be like an ancient Latin legal scholar, then you might talk that way. But there are certain phrases and terms that either the statutes or the higher courts have said, this is how you describe something. So I apologize if some of the phrases seem a little stilted. That's not me trying to impress you with big words. Not at all. I want you to follow this as closely as you can. So apologies in advance that I have to say things like abandoned and malignant heart. That's just one of the phrases that comes up in murder trials. Without further ado, I'm going to stand for some of this. I may sit. I think the more I move and do things differently, the more you'll stay engaged. Feel free to listen, watch, however you're going to absorb this. But this is the jury charge in the state of Georgia versus Jerry Hodges. Let's see if I can get my PowerPoint to work. There it is. A grand jury has indicted the defendant for murder, felony murder, armed robbery, burglary, aggravated assault, and possession of a firearm during the commission of a felony. That's this indictment, which you will have to consider during your deliberations. The defendant has entered a plea of not guilty to these charges. Those are all the signatures that you'll see on the indictment. The indictment and that plea of not guilty form the issue that you are to decide. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent until proven guilty. This presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state bears the burden of proving beyond a reasonable doubt every material allegation and essential element of each crime charged. There is no burden of proof upon the defendant, and the burden never shifts to him to introduce evidence or to prove anything. If a defense is raised by the evidence, the burden is on the state to negate or disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical or engineering certainty. A reasonable doubt means just what it says. It's a doubt based upon common sense and reason. It's the doubt of a fair-minded, impartial juror honestly seeking the truth. It doesn't mean a vague or an arbitrary doubt, but is instead a doubt for which a reason can be given, a reason that arises from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering all of the evidence, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant a grave suspicion of the crimes charged, or that merely raises a speculation or a conjecture as to his guilt, is not sufficient to authorize a conviction. It is my responsibility to determine the law that applies to this case and to instruct you on that law. That's what we're doing right now. You are bound by these instructions. It is your responsibility to determine the facts of the case from the evidence that has been presented. Then you must apply the law I'm giving you now to the facts as you find them to be to see if the state has met its burden. You must decide this case based only on the evidence presented during trial. Remember the no Google search instruction. That evidence that you've received consists of all the witness testimony and all the exhibits admitted. And you'll have those exhibits with you back in the jury room to look at and work through as you see fit. Evidence does not include, as I've said several times, the indictment or the plea of not guilty. It does not include anything I've said. It does not include anything the lawyer said, to include their opening and closing remarks. And finally, evidence doesn't include questions. All the questions you've submitted, those aren't evidence. It's only answers that are given. So remember, you may have asked a question that you thought was the whiz-bang question, but legally it wasn't a proper question, and so it didn't get asked. That is nothing you should draw any conclusions from. The evidence you've received may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact. This would be an eyewitness. I saw the car run the red light and hit the pedestrian. I saw it. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. So I didn't see the accident, but I heard squealing tires and someone said, "Oh my God." And I think that's when that car hit that person. I didn't see it, but I heard these things. There's no legal difference in the weight that you may give to direct or circumstantial evidence. In considering the evidence in this case, You may use reasoning and your common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or the believability of witnesses in this case. In deciding this, you may consider the evidence, the witness's manner of testifying, their basis for knowing the things about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their possible bias for or against a party. The credibility of a witness may be attacked by disproving facts to which the witness testified. You may also consider, where applicable, other evidence offered to attack the credibility of witnesses, including evidence of a witness's bias for or against a party. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You've heard from several witnesses who I designated as experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to an average person. These witnesses are permitted to give their opinions based upon that training and experience. However, the testimony of an expert, like that of all witnesses, is to be given only the weight and credit you decide it is entitled to receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided that you find that witness's testimony to be sufficient. Defendants in criminal cases who have no burden to prove anything are not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. Identification. The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. The defendant does not need to show that some other person committed the alleged crimes. Factors that you may consider in assessing the reliability of any identification that's been made in this case include, number one, the opportunity the witness had to view the alleged perpetrator at the time of the alleged incident. Number two, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident. Three, whether the witness's identification may have been influenced by factors other than the view the witness claimed to have. Four, whether the witness on a prior occasion did not identify the defendant as the perpetrator. And five, the length of time between the crime and the out-of-court identification. If you have any reasonable doubt about whether the defendant has been sufficiently identified as the person who committed the alleged crimes, it would be your duty to acquit him. You've received evidence of fingerprint comparison work in this case. Identification by fingerprint comparison is expert opinion evidence and is dependent upon the credibility of the expert witness called for that purpose, as well as the credibility of the witnesses who perform necessary functions in making the comparison, such as ink fingerprint impressions and latent lifts, and the accuracy of procedures in identifying, preserving, and maintaining the integrity of the physical evidence. If you decide that the defendant's fingerprints were found and identified during the investigation of this case, their evidentiary value, if any, would be diminished to the extent that they could reasonably have been left at the crime scene at a time or under circumstances that are consistent with innocence. A guilty verdict may not rest upon fingerprint identification alone unless you are satisfied beyond a reasonable doubt that the defendant's fingerprints were found at the scene and that he impressed them, stuck them there at the time the alleged crimes were committed. All right, we're going to turn to the crimes that have been charged in this case. First, what is a crime? The defendant is charged with crimes against the laws of Georgia. A crime is a violation of law in which there is a joint operation of an act, some action, and intention. Intent is an essential element of every crime and must be proved by the state beyond a reasonable doubt. Criminal intent is not the intent to violate the law, but rather it means simply the intent to commit the act that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find that intent, or the absence of it, from consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime if he directly commits the crime or if he intentionally helps in the commission of the crime. Any party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was actually committed and that the person was a party to it, even though the person who's alleged to have directly committed the crime has not been prosecuted or convicted. The statute of limitations. The law sets a time limit for the state to commence or begin prosecution of most criminal offenses. The defendant is here on trial for murder, felony murder, armed robbery, burglary, aggravated assault, and possession of a firearm during the commission of a felony. There is no statute of limitations for murder and felony murder. Prosecutions for armed robbery typically must begin within 7 years of the commission of the offense. Prosecutions for the remaining crimes that I listed typically must begin within 4 years of the commission of the offense. However, you must exclude from your calculation any period during which the identity of the person who committed the crime was unknown. If you find from the evidence that the indictment in this case was not filed within the time allowed by law, you must acquit the defendant as to those offenses that are time barred. It is the state's burden to prove, beyond a reasonable doubt, that each offense occurred within its statute of limitations, including any extension due to the perpetrator being unknown. Venue. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt as to each crime charged. Now to our substantive offenses. Murder. For murder, the state must prove 3 things. The state must prove that the defendant, 1, caused the death of another person, 2, did so unlawfully, and 3, did so with malice aforethought. Malice aforethought would be one of those phrases that's in the law. The killing must have been done with malice to be murder, but malice, as it's used in terms of murder prosecutions, isn't necessarily ill will or hatred. Rather, it is simply the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with a deliberate intention to unlawfully take the life of another. You may also find malice when there does not appear to be significant provocation and the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, i.e., with unlawful intent, It is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. It can be formed in an instant, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing, and it moved him to do it, that is enough for the killing to be murder. Proof of motive is not essential to the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes the defendant's state of mind at the killing. Felony murder. Now, there are 3 counts of felony murder in the indictment, but it's the same elements for each of the 3. For felony murder, the state must prove that the defendant, number 1, caused the death of another person, 2, by committing a felony, hence felony murder. The state does not have to show that the defendant acted with malice to prove felony murder. And I'm telling you that armed robbery, burglary, and aggravated assault are all felonies. You may find the defendant guilty of felony murder if you believe that he caused the death of another by committing the felonies of armed robbery, burglary, or aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death occurred. Armed robbery. For armed robbery, the state must prove that the defendant, number 1, took someone else's property, 2, from that other person or from the immediate presence of the other person, 3, by using an offensive weapon, and 4, with the intent to commit theft. An offensive weapon is any object that is likely to cause death or serious bodily injury if used against someone. Burglary. For burglary, the state must prove that the defendant, number 1, entered the dwelling of someone else, 2, without authority, and 3, with the intent to commit theft. And that term dwelling includes a house or any other building that is intended to be used as a residence. Aggravated assault. A person commits an assault when he attempts to commit a violent injury to another. A person commits an aggravated assault when he assaults someone else with a deadly weapon. The state must prove as an essential element of aggravated assault, as it's charged in this case, that the assault was committed with a deadly weapon. And I instruct you that a firearm is a deadly weapon. And the final charge in the indictment, a person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. Murder, felony murder, armed robbery, burglary, and aggravated assault are all felonies. And that term firearm includes any handgun. Let's talk a little bit about any verdict you might reach. You should consider each count in the indictment individually. The defendant may be found guilty of some, all, or none of the charges in the indictment. If, after considering the evidence, together with the charge that I'm almost done with, you should unanimously find beyond a reasonable doubt that the defendant did commit in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. And in the blank on this verdict form that you'll be filling out, for that particular offense, you would write the word guilty. It's already, well, actually, you're not going to, this doesn't match the verdict form. You'll check guilty or not guilty. This particular verdict form, and they're different every trial, for count 1 murder, we find the defendant, there's a blank and the word guilty, there's a blank, not guilty. So if all this applies beyond a reasonable doubt, you unanimously find him guilty, then you check guilty for that particular offense. All 8 offenses are on this verdict form. All 8 have guilty and not guilty. check 1 if you're checking anything. And again, you may find the defendant guilty of some, all, or none of these offenses. If you do not believe that the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. And in the appropriate space on this verdict form, you would check, not write, next to the words not guilty. Whatever your verdict is, it must be unanimous. Your overall verdict must also be in writing, signed by your foreperson, it's a signature block here, and dated. By no ruling or comment that I have made during trial have I intended to express any opinion upon the credibility of the witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence according to the laws given to you in this charge. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. Ladies and gentlemen, you are the fact finders in this case. You are not to concern yourself with punishment. You will play no role in sentencing. That is my job. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign this verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any outside research. You have all the evidence you're going to get in this case, and it would be improper for you to supplement it with any outside information. To help ensure that you live in a little sealed cocoon while you deliberate, Deputy Gordon will be collecting your electronic devices, to include Apple Watches, anything else that communicates with the outside world. We'll hold on to them. I promise you'll get them back each day. If you come back tomorrow, you'll get them tonight. But while you're in that jury room deliberating, you're going to have to take a little break from the iPhone or the Galaxy or whatever you've got. And finally, going forward, should you need to communicate with me for any reason, a question, a concern, it needs to be in writing. You've got good experience with it. You can write on a note card or from a page in your notebook. And when I receive your question or your note, I'll confer with the lawyers and Mr. Hodges and share with you whatever response I'm authorized by law to give. And I have to use that phrase, authorized by law, because sometimes you'll have a great question and then I have to write back, you're going to need to rely on your collective recollection. I told you before at the start of this trial, you don't get transcripts of witness testimony. So if your first one is, hey, can we have Detective Zimbrick's transcript? Nope. You have to rely on your collective recollection. But I'll do my best to answer questions if you've got them. And with that, you've received the charge of the court, and I'm going to ask all but two of you to retire to the jury room and start unholstering all your electronics so that Deputy Gordon can get them. But Ms. Yen and Mr. Porter, I need you to stay put. So 12 of you back to the jury room. Please don't start your deliberations until you get the stack of evidence. I think he's going to actually roll a little cart in there. The evidence, the verdict, the indictment, and the jury charge. Okay?
All right,
All right. You two are our alternate jurors. You are here because one never knows when we might lose a juror because they went on a trip to Jamaica and they got COVID and they couldn't continue to serve. So we need to have backups. you're going to stay here today as well. You can keep your electronic devices if you're an electronic device person. Are we going to put them in that? We've got a backup jury room where there's a little green hurricane or tornado on it. That's where you guys are going to be. There are bathrooms in there. I promise we won't forget about you. When this group goes home for the day, if they don't finish today, we'll talk to figure out whether you want to come back here tomorrow or whether you can be close enough that if I call you saying, uh-oh, we lost a juror, we need you to come down, you could be here in 20 minutes or so. I don't remember where you all live, but if it would take an hour to get down here, you'll just need to come down here and hang out. You can work, whatever you need to do, you'll have that room. And you two can talk, just not about the case, because we may need to press you into service if we lose one of these 12 jurors. So you're going to get your stuff in just a minute. Deputy Gordon will get you into that room. Don't leave. When they break, we'll let you know. And if for some reason there is a resolution today, we'll let you know about that as well. It's only if the jurors are coming back tomorrow that we'll talk about what your day tomorrow looks like. Any questions about that? No? All right, once you guys go in the jury room, grab your stuff, and then Deputy Gordon will get you to the other jury room. Ms. Ockham, any exceptions to or objections to the charge as given? Ms. Feely or Ms. Primovic, other than objections you've already registered, anything?
Yes, Your Honor, I did not catch that the single witness was not a pattern charge. And
Okay.
that was our request for the pattern charge.
Okay. Is there something you think I need to correct? Because it or add, or what, tell me what your concern is. A lot of the charges are built off the pattern charges, but are made more accessible in my mind. So we can talk in just a sec. All right, you were saying.
We would request the testimony of a single witness, if believed, is sufficient to establish a fact. And then the following, generally, there is no legal requirement of cooperation of the witness, provided you find the evidence to be sufficient. Just those two little clauses. So the clause about sufficient is in there. It's just the if believed. Yes.
Okay. All right. Your concern is noted and objection to the modified pattern charge is noted. Anything else?
No.
Okay. I need one phone number from each side that we can call that will get whoever each side wants to be in here when, if and when the jurors have a question or a concern or a verdict or who knows what. Mr. Hodges, we'll bring you back out for anything that happens. If the jurors have a question, we're talking about it, we'll bring you out here. If they want to go for the end of the day and I'm excusing them, we'll bring you out here for that. But while they're deliberating, I'm going to have you stay back in lockup. All right? Okay. Thanks. Ms. Rivers, I'm going to give to you. I guess we'll wait till we get off the record. Where's 608?
Wisconsin.
Wisconsin. All right. Great. Well, we will be in recess until I hear from Deputy Gordon that we need to re-engage because the jurors have something we need to address. Thank you, everyone, for your hard work. And you can be at ease for right now. This is Oh, right, you need to, not you can't be at ease. Here's
They get all that stuff.
verdict, indictment, charge. But we have a million, yeah, we have a million more if we need. That's Courts Exhibit 1.
I don't know the reason things are changing, but it's a baby. It's a baby.
Let me see now. Oh, my Yes. From where? What was she? What was she?
No, they wanted to.
Making sure you. Is it 20 minutes?
You're jinxing.
I'm jinxing you?
You're jinxing.
Did she do 5 years with
It's court sweet.
I can't stand her, I'll let her have that then. It's never clean it out.
He's in a different courtroom. You guys know what the Dunaway trial still going? Which one? Dunaway, started with Monique Thursday.
Did it go?
I thought you didn't go.
Did it go?
Better information.
Yeah, I thought it.
I thought it did.
Okay, I'm good.
Oh, wait, that's the one that they picked the jury Thursday, and then they're supposed to start today.
Oh, that's what,
That's
okay.
Adams. With Jeffrey Lee.
No, it's
No.
Monique, is what she said.
Yeah, with Monique Warner.
Monique is it, yes. No, that's what I'm saying, but it's not apples, no atoms, a body, is it a murder?
Yeah.
Yeah, that's going to jury Thursday.
Okay.
I don't know, because they were,
I had them around, so.
maybe they was out, that thing made them offer. Right, you go find those bullshits. Now, anything you want.
Oh,
We were, big moments when we believe that the child is a lot of stories. Not something. What I should. Yeah, make it. All of a sudden, 2001, we'll get. Years. Didn't get his way. So the home was mostly this. I mean, he was whatever. My wife said, you get a girl friend. You're gonna find, you know, they look, everything. I'm never. We had that. Yeah, and one of the big benchmarks was locations. And then he says, how one of the things that he was something that's like, you know, a lot of basic stuff. And it's like, you know, the teacher, right? How I was going to talk to the so little things like that, you know, and it's just, I'm so embarrassed. Where's Diane? I'm looking for Diane.
Oh, look at you, you stick up with the other.
So I had to talk to you yourself. Yeah. Oh.
Yeah, I hate it so bad.
It's so efficient. You know, you guys have a wonderful legacy. And you just, everything we do, yeah. Oops, okay.
Right.
Just get there.
Right.
Just keep going, because he is really doing this right. He was, when he was going up to Washington. Like inside the city, there's a district.
Yeah.
No, you're retro. Oh, yeah, you betcha. I'm in the city. So anyway, you say, okay, I was just saying. Oh, turn, yeah, the theater center is probably, but he's back on.
We have that in common, I think go to Holland.
I was accepted George Washington. I didn't want it there. I wanted to say, kids, a good thing with the alumni of Washington University. She said, kids took over Clinton's office. She said, just go up there, don't like these kids, now they will deal with that. My mom didn't consider, that lady was a family of three. I got my mother first down. And mom was that. Same like that, you know, we just kind of realized kind of. So there I am, Boston University. I don't know because it wasn't a good, I knew it wasn't a good match. And I got there, and I smelled it. I smelled it very. But I think because the chick over here, like, August or something, because all the that was the only thing that opened. Well, I said,
So, yeah.
all science. I like so I said, well, I believe that education is really start guns. I said, okay, I'll be that would be my major.
I can just.
You know, yeah.
I can tell
I got a transfer from school and coming out of the arts. Yeah, arts college. All the credits. Yeah. Because the will did it. When I
Died.
I didn't see why I couldn't sit school bed, courses, school good, good, they're going good. I didn't see that. And it's the same university. I was so shocked. I did, but later on, and I still gotta do it. Scientific thing just to prove is not my speculation. The way what my party line started as the liberal arts, the College of Arts and Science. And then after a few years, decided to go to state school. Because you probably I did it the other way around. That's what I thought. Well, here's what they did. Because they said, you know, well, they did their whole thought. They gave me, no, they do no push up. They do very good. You took the college course. General education at Cole University, where schools got moved up. One of the major schools generating doctors for this. The computer department is perfect, top notch. It's summer. We can cram it all into the sugar factory. And then they split the lab the class. I knocked it out. Not even thinking of what one week. You know, they even start with this. Got no questions. Okay. I got 10 hours with a B plus or something like that. Good stuff here. One university son. They said we only going to give you credit for hours with that. We're going to calculate. We have 8 hours at 0.0 per grade. And the summer school, I think the summer school is something. Which you got money. I'm on vacation. My first semester back, I had to take off. The salary was first semester. Because I said, I'm going to punish my own students. I was how that people, individuals, walk out from the public schools and go to their own school. What if I don't even still get radio? That's what I've heard. They were found to be awesome. Anyway, so I had to do salvage, I went through salvage, the first thing I should and so what you make it why? Because all the time. Yeah, another story. I had one, and I just,
When he was just shot.
He's almost there. Just so. Oh, yeah.
Okay. Did you hear?
Are we running?
I wasn't here.
Oh, that's good.
So now you see how you get that. I'm gonna watch them. It don't matter. We all yeah, and you just can't stand there. All over the way. All you have to do is do that. Just something. But I'm not saying.
legislature.
I see you. I see you. Yeah, I ain't got, I don't know about going up that high. Yeah, I see you. Yeah. Yeah, well. Yeah.
Oh, wow. Wow.
I was like, I usually just live. Okay.
I want to go
This is my favorite. I just had one.
Come on, Sean, come with me. Where you coming from? Where you coming from? We're good then. This is good. Call me too.
That was what it is. This whole yeah. He was trying, but he just. Oh, yeah.
Oh, I said. We were over and I laughed so hard. He just like, he just kept that. So they accepted unvetted with intoxication. Unvetted. Explain that to him. So he was drunk and he do this.
Don't make sense, I can't explain.
And we were all just like, what? This was like, and they were.
How did it justify it?
No. You just know that it's so they felt it was a bold and misleading.
That's not. That's not. Yeah.
She said that she wanted to break.
Okay.
So,
Her son?
yes.
Okay.
Superstitions.
You know, never. So sure.
It won't get there. You make it 30 minutes. You know, you make it under 30 minutes. And then have this whole thing where you had a whole, one of the prosecutors later, it's probably like, I think it has to be under 30 minutes, like, this we had a whole Thursday morning meeting. Everybody say their job. Anything comes to outrage, like outrage, I'm just a rag. So go ahead. It's like 15 minutes. So when I record, I was like, it might not. They might not have been until 30 minutes after.
The clock was up in 15 minutes. That's up. I like that.
So that means they.
Wow, like, nothing. But that's not. No, leave it out. So what made your officer?
Because 1%.
So if, as long as he puts a subpoena in his hand for that day, before we release it, I mean, theoretically. Yeah. So you're saying you don't think we have to? I want to know what I but I need to know what the order says. No. You saying her order says oh, let me see what else. Does it say anything else? Well, he needs to type. Let me just make sure that ain't nothing illegal about it. I need to find material. Let me call.
No, it's just.
Oh.
Okay.
He just talked to me. I was just calling you because I'm trying to find, this is not thought. But I'm gonna find the law before I do it. If he has it, let me find the law. That's Richardson.
Because I have a subpoena for the. I got that.
Hold on, because if you walk around, I'll say it in your ears, but.
Yeah.
Is there any, is there any, is there any statute? I don't need to do it. I definitely need to do it. Please know what I can and I didn't.
That's pretty, I like that.
So what's the next chapter?
I sent it to you.
I might have to get out and bring it back in.
I don't see it in my statement.
I'm keep looking for. Are you sure you sent it to me?
No.
There it is. Wait, I got the apps. They're ready to out. It doesn't have any. Huh?
That's just something on the floor. It's above. Yeah. Could be probably thing there.
I'm gonna find the answer. Huh? Who is you are? Okay, I'll stay. Generally. You're gonna take, this, no, you should be that. What? You don't know what. Move. Rub up.
Like if we.
Done that on many occasions, sitting in the restaurant. I had to leave.
Right.
Now we can go back. It's not gonna be pretty.
What happened? Did he?
How long we been out?
Well, they see. You call the victim, the advocate's meeting.
Yes, I will. We have a light, I don't know what it is. Hold on, let me just show you. They do have a first question, and I don't know which one it is. Might have to start over because it's burnt. Okay. No. I have to. Yes, this number down. Solid number 20. So arguably, I'm probably 10, 20. Yeah. Question? Yeah.
Mr. Rogers, on your shoes? Yeah, Mr. Rogers, my shoes.
Yes. Yeah.
Right now.
Well, my order, remain seated.
All right. Ms. Rivers, you ready? We've got Mr. Hodges back in here. Two questions, they're connected from the jury. I will read them into the record. This will also be, hold on one second. Made a part of the record. Question one, if we believe the defendant was party to the crimes committed on 16 March 2007, does malice have to be proven for a murder charge to be applied? Or does party of the crime apply to murder, even if malice or proof beyond a reasonable doubt of who committed the murder is not proven? Two, if the answer is no, are there lesser crimes other than murder that we should consider? Other crimes that are not on the indictment?
Last sentence is a two-part.
Sure. If the answer is no, are there lesser crimes other than murder that we should consider? Question mark. And then there's an arrow. Other crimes that are not on the indictment. So the author is asking, are there lesser includeds that we should be thinking about? So my proposal is not that we bring the jurors out, but that I write legibly on this question. If you believe that a murder occurred on that night and the defendant was a party to it, you may find him guilty. If you do not find, I've put beyond a reasonable doubt in there. If you find beyond a reasonable doubt that, I should probably make it clear. If you find beyond a reasonable doubt, let me write it out and draft, and then I'll read it to you. Sure, if you want to get it from Deputy Gordon, and then I will not worry about bad penmanship right here.
Yes. Yes. Yes.
All right. Is what's on your screen big enough that you can read it, or should I magnify it?
It's big enough, I can read it.
Ms. Feely, you're getting kind of squinty. Can you read it? You can also angle, well, I guess Mr. Hodges needs to see it as well. I can make it bigger. You make it 1.
Yeah, that sounds perfect.
Well, now the defense isn't going to like it because you called it perfect.
That is rubbish.
I don't know about rubbish. Exactly.
Please correct Sale.
That's my focus. Is it correct?
I think it's correct. That's the state of the law. That's the correct statement of the law. Because I was gonna ask whether elements of murder to be read, but you have that stated, that it's in your charge.
All right, I heard a lot from the state. Ms. Primovic, Ms. Feely, your thoughts about that? I'm happy to tweak the wording. I'm just trying to respond to the questions and keep them more on track. They seem to be getting off a little. Well, the order's in the news now. The whole order is there. There's an article, and then the whole order is in. So we'll see what happens. It is being obscured by all this Giuliani stuff, which is good, except that it doesn't get us out of the. What crappy luck. Ms. Feely, Ms. Primovic, thoughts?
That looks all right, Your Honor.
Okay. I think what I'll do is print this out and sign it and staple it to this. That way it addresses any legibility issues I have, of which there are many. For your planning purposes, I'll let the jurors go until, I guess we'll probably check in with them around 5. If you don't, you will check in with them around 5 to see if they want to keep going. Probably they'll let our alternates go then for the day. But if they want to go past 5, we can't let them go a whole lot past 6 just for transportation reasons. But we'll take their pulse at 5, and I'll hear what Deputy Gordon has to say. Ms. Ocom, anything else from the state?
No, Judge.
Ms. Primovic from the defense?
No.
All right, thank you You may have never left, but you were all in here when I came out. That's always helpful. Thank you. All right. Thanks.
Just nothing that's right there in your face. Because I don't think we should. I'm not saying yes, but I don't think we should be required. Just be with me. So you know, English, but not necessarily. Is well. That's what I'm trying to, that's, yeah. Okay. Great. And we can do Yes, ma'am. Sorry about that.
I've never had it.
Everybody else is still just. There's a clock tower. That was. He just says. So he doesn't know. First paragraph. Security guard. Goes out to the cell. He's a state worker. I said, he grabs those guys, he takes the cover. They have to do this guy. Jack, he's got hold of the jack. The guys, I'm scared. I said, you got all these multiple jurisdictions. I said, yeah, that's state. City.
Wait,
He couldn't look, but like I said, hopefully, but to this. Yeah. Sometimes I'm saying, somebody coming down, all you're gonna see is here's the guy coming over with this. Oh,
Can we bring Mr. Hodges out, please? All right, Ms. Rivers, are you ready? I have been told that the jury, we got everyone here. We have Mr. Hodges in here, that the jury has reached a verdict. So my proposal is to bring the jury in and see what that verdict is. Ms. Ocom, anything before the jurors come in?
No, Judge.
Ms. Primovic?
No, Your Honor.
All right, let's bring them in, please. They can sit tight for right now.
All right, the jury. All jurors present.
Thank you, Deputy Gordon. Everyone can be seated, please. Are you the foreperson? Ms. Dill?
Yes, sir.
Great. Have you reached a verdict? You meaning, has the jury reached a verdict?
Yes, sir.
Was it a unanimous verdict?
Yes, sir.
And have you, as the foreperson, completed the verdict form, signed it, and dated it?
Yes, sir.
If you could give Deputy Gordon the verdict so I may see it. Ma'am, I'm going to ask you to stand and publish the verdict, which means read the verdict into the record. You don't have to read the stuff at the top. You can just start with count one and make clear on the record what the jury's verdict was.
Yes, sir. Count one, murder, we find the defendant guilty. Count two, felony murder, armed robbery, we find the defendant guilty. Count three, felony murder, burglary, we find the defendant guilty. Count four, felony murder, aggravated assault, we find the defendant guilty. Count five, 5, armed robbery, we find the defendant guilty. Count 6, burglary, we find the defendant guilty. Count 7, aggravated assault, we find the defendant guilty. Count 8, possession of a firearm during felony, we find the defendant guilty.
Thank you. And you signed it and dated it, as you said.
Yes, sir.
Okay, Deputy Gordon, if you could get the verdict form to Ms. Ocom, and then Ms. Ocom, if you could get that to the defense. Ms. Ocom, do you have any objections to the form of the verdict? Ms. Primovic, do you have any objections to the form of the verdict?
No, Your Honor.
Ms. Ocom, any motions before or requests before I excuse the jurors?
Not for mistake.
Ms. Primovic,
I request to pull the jury.
I'll do that. Ladies and gentlemen, I'm going to call you in numerical order. When I call your name, if you would please stand, I'm going to ask each of you the same 3 questions, just verifying that this is your verdict. And then I will be in a position to release you from your service. Mr. Olson, was the verdict read here in court your verdict back in the jury room?
Yes, sir.
And did you freely and voluntarily enter that?
Yes, sir.
Is it still your verdict?
Yes, sir.
Thank you. Ms. Brookins, was the verdict read here in court your verdict in the jury room? Did you freely and voluntarily enter into it? Does it remain your verdict? Thank you. Ms. Clayton, was the verdict read here your verdict in the jury room?
Yes,
And you freely and voluntarily entered into that?
yes,
Is it still your verdict?
yes.
Thank you. Ms. Dill, was the verdict that you read here in court your verdict in the jury room?
Yes, sir.
And is that something you freely and voluntarily entered into?
Yes, sir.
Does it remain your verdict?
Yes, sir.
Thank you. Mr. Hillis, was the verdict read here in court your verdict in the jury room?
Yes, Your Honor.
Is that something you freely and voluntarily entered into?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Thank you. Ms. Giacomini, was the verdict read here in court your verdict in the jury room? Did you freely and voluntarily enter into that? Is it still your verdict? Thank you. Mr. Mays,
Sir.
was the verdict read here in court your verdict in the jury room?
Sir.
Is that something you freely and voluntarily entered into?
Yes, sir.
Is it still your verdict?
Yes, sir.
Thank you. Mr. Farnsworth, was the verdict read in court your verdict in the jury room? Did you freely and voluntarily join in that verdict?
Sir, I did.
Does it remain your verdict?
Sir.
Thank you. Mr. Poole, was the verdict read here your verdict in the jury room?
Yes.
And is that something you freely and voluntarily entered into? Is it still your verdict? Thank you. Ms. Bryant, was the verdict read here your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into that verdict? Is it still your verdict? Thank you. Ms. Keough, was the verdict read here your verdict in the jury room?
Yes, sir.
Did you freely and voluntarily join in that? Does it remain your verdict? Thank you. Last but not least, Ms. Braswell, was the verdict read here your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into that verdict?
Yes.
Is it still your verdict?
Yes.
Thank you. Making sure I got everyone. I did get everyone. All right, ladies and gentlemen, in just a moment, you're going to go back into the jury room. Deputy Gordon will return your electronic devices. We have letters for each of you indicating where you've been in case an employer or a significant other says, where you been? That should cover it. If it doesn't, have them call me. I will fix it. But that letter is typically enough. It lists all the dates that you've been here. Everyone involved in this litigation appreciates your service. Every case is unique because it's a different victim, a different family, et cetera. This is the first time I've dealt with a murder from 2007. So it was different on a lot of levels. But you stayed focused and put in some hard work and allowed there to be some closure insofar as there can be closure when there's a tragedy like this. So thank you for your service. I'm going to come back and say thank you again, answer any questions you may have. Once I've done that, you're free to go. Some of you may choose to stay because lawyers often like to ask questions about how it went, what they could do differently. That's optional. Talking to me, not optional, but I'll keep that short and sweet. Thank you so much. You'll get the alternates in there? There's no rush. They just eventually need to get in there and get their letters too. Thank you. All right, everyone can be seated. Ms. Ocom, do you have a what is your perspective on whether we should do sentencing now or soon?
No, Judge, because I have this.
Dr. Canada is here.
Out of town, it's just here, so we'd like to do it today.
Okay. Ms. Primovic, what's the defense perspective on sentencing?
We understand that issue, Your Honor. I would just ask if my client's hands could be
In front of him?
front, so it'd be a little more comfortable.
Sure, I'll talk. I don't have an issue with that. I'm not the security person. I think there was just an immediate securing while we went through this. We're going to take a quick break while I excuse the jurors. Mr. Hodges can go back into lockup, and then I'd ask, as long as it's consistent with security protocol, that he be cuffed in the way any other inmate would be coming in here. And so I think that means in the front, but I defer to you all on that. But we will then turn to sentencing and close out this situation. So be at ease enough, and I'll try to be here as close to 5 as I can. I'm just going to talk with the jurors. Thanks.
Yes. Okay. Tell Julia.
Yes. Yes, yes.
Okay. There was. There's conflict. Yes. Okay. Yes.
Or come to order.
Do you have enough personnel to bring, I know Deputy Gordon is stuck back there with the jurors. If we've got enough folks, let's bring Mr. Hodges out. Great, thank you. All right, Ms. Rivers, you ready?
Yes.
We are back again in State versus Hodges. The jury has delivered its verdict of guilty on all counts, and we are turning to sentencing. Ms. Ocom, I'll hear from you in a moment, just so we don't have to spend a lot of time on the logistics of merger and whatnot. I find that counts 2, 3, and 4 are vacated by operation of law, and 7 would merge into 1. So that's at a minimum. There may be other merger arguments that folks want to make, but I believe we're sentencing as to count 1, 5, 6, and 8, and no others. It may be fewer than that. It's not going to be more than that. And with that, Ms. Ocom, or Ms. Love, whenever you're ready.
Thank you, Judge. Judge, the state of Utah, your assessment of what would be sentenced on. As to count 1 for the murder, the state is asking for life. As to counts 4 and, I'm sorry, I apologize. As to counts 5 and 6, the state is asking for 20 years each on each of those charges to be consecutive to the life. And as to count 8, we're asking for 5 consecutive. So it would be a total sentence of life plus 45 years. The state is asking for. I would note that because the defendant is a 2007 armed robbery at the time, sentencing for armed robbery in 2007 was 10 to 20 years or life. And then the sentencing for burglary in 2007 was 1 to 20 years. But the possession of the firearm remains the same. And the state also has 3 witnesses that will speak. Mr. Stephen Buchanan, Dr. Kristen Canada, and Zaire Buchanan. I would ask the court, do I make my arguments before they speak or after they speak? Or
You do it how you want to do it.
I would ask for them to speak first. first, please. This name calls Sydney Buchanan.
Okay. You said the name was Sydney?
Yes, sir.
Okay. Pretty sure you can check. In fact, I want you to have the verdict form. All right, I'm sorry, I had to handle a procedural matter. Give me one other. All right, good afternoon, sir. If you don't mind removing your mask and stating on the record your connection to Mr. Barry Buchanan.
My name is Sidney Buchanan. I'm the father of the.
Do you spell Sydney with two Y's? Okay.
UCHANAN.
All right. Thank you for being here, sir. You're welcome to read it. Just make sure you read it slowly enough that the court reporter can take it all down.
Sure. This is my impact statement of August 15th, 2022. This is on behalf of my family, wife and daughter, and extended family and acquaintances. Loss part one. I was robbed. My enduring impact is a permanent loss for which there is no restitution. I do not understand the mentality that allows for the taking of things from others. In this case, that attitude resulted in the taking of another's life. This is the ultimate robbery for which my family and myself cannot be made whole. We've been robbed of a son, brother, cousin, nephew, grandchild. We lost someone who made the world a better place for those who came in contact with it. Loss part two. What hurts me most of all is that I was denied seeing my son become a father. Based on his caring attitude and actions toward his friends and compatriots, he would have made a good father. In fact, his concern for his girlfriend and unborn child led him to exit the initial crime scene to check on their well-being rather than running away. Senseless. This murder did not need to occur. The crime had already been committed. The escape had been made. This was unforgivable malice. Forgiveness. While I'm not out for revenge for this unnecessary act of violence, I do not wish upon another family this to occur. Thus, I do not want the defendant to be released into society with the taking from others' mentality still operational. I'm not aware that any remorse has been expressed, and I wish for a full sentence. Thank you.
Thank you, Mr. Buchanan, for sharing that and representing the entire family.
The second witness would be Zaire Buchanan.
Good afternoon. Can you come up a little closer, right to the corner of that table? And if you'd spell, we got the last name spelling now. How do you spell the first name?
Dahir.
All right. And what do you want to share?
I wanted to share what the defendant did to my father and how it affected me. I just wanted to let you know.
So you need to talk to me. Your words can go to Mr. Hodges, but look at me.
I wanted to let him know that him taking my father over a senseless act of violence wasn't okay. It's affected my life a lot. I had to learn how to shave by somebody else. I had to learn how to change a tire by somebody else. And it's like caused me to build up a lot of anger inside, and I just haven't had the chance to let it out yet. And
do you talk to people? I don't mean strangers, but do you have someone you can talk to about what you're working through?
yes, sir.
Good.
And I do hope that he has time to think and really think about what happened and what he did wrong, because I don't think that he showed any remorse or anything that showed that he cared about the situation and what he did 15 years ago. That's all I have to say.
Well, that's not all. That's a lot. Thank you for sharing it. So you're 15, you're a sophomore or a junior. Where are you in school?
No, I'm starting as a freshman.
Excellent. Where are you going?
Kirkland Ranch.
And you're with your mom, wherever your mom is, or where do you stay?
I live with my mom here.
Okay. So have you started high school? I know you said I just don't know when school starts.
School starts as soon as I get back home.
Okay. Well, I want to make sure you get back there. Good luck with high school and thank you for being here.
Thank you, sir.
Your Honor, State calls Dr. Kristen Canada.
Hello, doctor.
Hi,
We know how to spell your name.
I just want to say that this event this was the most traumatic experience I've ever had. Yes, I remembered his face because I saw it every day. I replayed that night over and over and over. I felt guilty because I felt like I should have done something more to stop it. I don't know what. My son, at 3 years old, cried to me because he did not have a father like other kids. A gut-wrenching, guttural cry. He didn't get to experience whether Malik was going to be a good dad, a bad dad. Malik was a great guy. He was charming. Everywhere he went, he spoke to people. He greeted homeless people on the street. He was funny. Everyone loved him. Like, he was going to be a great dad. And my daughter, he was great with her. We were just so excited for the future, and to have that robbed over some clothes, that is shameful. I hope that the time spent in prison is spent reflecting on your actions. I'm sure this wasn't the only thing that you've done that is wrong, So reflect on that. Try to change the character of the man that you are. Be better. That's it. That's all I have.
I appreciate you sharing that. And thank you for your testimony during trial too. I know that was not easy to have to talk about, but it was necessary. Thank you so much for being here. Ms. Ocom?
Yes, Judge. Your Honor, I understand that the defendant was 16 at the time that this was committed, but the egregiousness of it, the state cannot. Because you've heard all this testimony, I'm not going to go through it again, but again, he did not have to die. There was no reason for this because he already made it out of the house and the robbery was done. And I think also important for the state is what the defendant did after. We had a 404B hearing, which Your Honor didn't let in, but there was a similar burglary. He went into somebody's house through the window and he was found in the apartment. That's not only that, there was another violent offense. It's an armed robbery that wasn't letting through 404B, but he at a MARTA station had a gun and tried to rob individuals of their items. So there's a pattern for it. So even though he had the chance when he was 16, well, he didn't have the chance, we just didn't catch him and he got away with it. He didn't stop. He kept committing crimes. So for his criminal history, what I'm looking at, I have obstruction of police when he was a juvenile in 2007. Then there's a robbery that the petition was dismissed. And the facts of that case is eerily similar to this. And I understand that it was dismissed, but basically the owner of the home said he came home and saw the defendant and his brother at the time trying to take a projector from his home. And then when he stopped them, one of them shot at him. I understand that the petition was dismissed, but there's a police report for it. And he was a juvenile of whatever happened in 2008. I think most glaring for it, the 2007 thing was it happened, I think a couple of months right after this burglary murder. And so he didn't change. So he got away with the murder and he did the exact same thing again. Then in 2008, as a juvenile, there's a robbery and a simple battery. There's a DeKalb County case as a juvenile that I couldn't get more information from, but that happened also in 2008. Then he had a possession of a marijuana in 2008 as well. And then we fast forward to the 2008, the armed robbery that the state wanted to get in as part of the 404. He was given first offender, but he didn't make it. He was revoked and he was found guilty of it. was pled down to a lesser, but it was an armed robbery. There was a gun, there were individuals, he pointed the gun and he did it, but they pled him down to a robbery. Did he take advantage of that? No, because he got his probation revoked, and that's why he got the first offender revoked. After that, there was another burglary in 2010. That's 10 SC 95422. So there's a pattern. So basically what the defendant likes to do is likes to take things from people that doesn't belong to him. And if you don't give it to him, he either points a weapon at you or he shoots you. Either one of them happens. So he's violent. I understand he was a juvenile at the time, but there's certain things that the state has to prove when asking for a life sentence on a juvenile. And one of that is what the defendant has done. And if he's violent and he has, if I want to make sure I use the exact language, Judge, I apologize.
Before you dive into that, you're saying something that confuses me a little bit. I believe that you would need to show, and I would need to find, that Mr. Hodges is incorrigible. That's one of the words, but that's for a life without parole. And I didn't hear you ask for a life without parole sentence.
That's not what
I don't think you need to prove anything beyond getting the conviction, the guilty verdict that you did for the life sentence. I don't think I need to find anything beyond a jury convicted Mr. Hodges of murder. I don't believe there is a less than life sentence option for someone who was 16 at the time of the murder. The distinction is life versus life without parole. And I'm now very familiar with how the findings that need to be made with a life without parole, but you have not asked for that unless you're changing up on it.
No, I haven't asked for
Okay.
that, but I'm asking because of the extra 45 years I'm asking for other than the life. I don't want it to run concurrent. want
I
it
heard
to
that.
have An extra
Okay.
45 years. That's why I'm going through all of this, Judge.
Okay.
And also after that, as to his the burglary, then he had a possession after that as well, possession of cocaine. And that was the last time that was revoked again in 2013. So he's been giving chances upon chances upon chances. And not only are his crimes, like he's committing crimes, but he's committing violent crimes. And he's going into people's homes and he's taking things from people with weapons. So he's violent. It's the state's position. And for his violence, he needs to get life plus 45 years in prison. That's what the state is asking for. I believe the facts of this case, the egregiousness of this case, as well as all of the other things that the defendant has done after he got away with this. It's one thing if he was out there for 12 years doing nothing and we just happened to catch him. But no, he just kept on committing crimes. He's gone to prison a couple of times, but that didn't change anything. And so for all of these reasons, Your Honor, the state believes that the defendant is violent. The egregiousness of this case that was unnecessary. The state is asking for life plus 45 years.
Thank you. Ms. Primovic.
Thank you, Your Honor. Your Honor, Jerry Hodges at this moment is 30 years old. When these the shooting occurred that he continues to deny. We respect the jury's verdict, Your Honor, and the system, but he continues to deny being involved with this 14, 15 years ago. Before his arrest in 2019, he was working at Papado's restaurant up there on Windy Hill. He had his GED, he was living his life. His 16-year-old self, Your Honor, as I think we all know, have impulse control issues. His 2010 armed robbery, reduced to robbery first offender, he was 19 years old. He, that's why we have juvenile court. That's why we have programs and things for his brain wasn't even formed, Your Honor, until he was 25 years old. So we're saying, Your Honor, that the life plus 45 years would equal 75 years that the state is offering. I think that's equivalent to a life without parole, which is an Eighth Amendment cruel and unusual sentencing for a young man, a young boy who was 16 years old. You have to give the life. We understand that. We disagree with the constitutionality of that with the 16-year-old, but as the law stands at the moment, that is what it is. We're asking, Your Honor, for you to sentence on the armed robbery 20 concurrently with the life, same with the burglary, plus 5 suspended. Your Honor, to make it a life plus 5 suspended. Anything more than that, Your Honor, is 30 years old. he's eligible for parole at 30, which would be he'd be eligible for parole at 60 years old. He has about 3 years in, so he would be eligible for parole around 57 years old. We add 45 years on top of that, that's equivalent to life without parole, and that is what the state is asking. So we are asking, Your Honor, for a total of life plus 5 suspended.
Thank you. Mr. Hodges, you have a right to share anything you want right now, but much like testimony, you don't have to say anything at all, but I need to give you the opportunity to say something if you want to. Is there anything you want to say, or are you going to maintain your silence? Nothing to say. Okay, understood. I appreciated the way that Mr. Barry Buchanan's father, Sidney, put it, that no restitution is possible. I've had to sit through a lot of murder sentencings. And I've never heard it put that way, but it is a concise way of saying there's nothing you can do to make Mr. Barry Buchanan's family whole. There's a son and a brother and a father who is forever gone. And he was taken because of one trigger pull. And I know the theme of the states was it was unnecessary. There aren't necessary murders. If it was necessary, it's self-defense, and we don't get there. So it goes without saying that it was unnecessary. It's just particularly tragic to Mr. Buchanan's observation that the crime was done. You took the guy's stuff, just get out of there and leave them with their lives so they can move forward and enjoy a child and a life with a loved one and parents, et cetera. That's the real tragedy here. That said, I also appreciate Ms. Primovich's observation that we're dealing with the 16-year-old mind. And while Zaire was very mature as he stood up there, I have a 15-year-old son, and he's a nice kid, but he also can be impulsive, and he makes decisions that are the product of a brain that is not fully formed and doesn't necessarily appreciate the consequences. That in no way justifies what happens. It in no way excuses it, and it in no way provides restitution to the Buchanan family. But I think it is a forthright recognition that we're not dealing with a 40-year-old man who gunned down Mr. Barry Buchanan. There was no reason for these 3 young men to be breaking into the apartment and terrorizing both Mr. Gooden and Mr. Barry Buchanan and taking their property. But we're also dealing with someone, it's sort of ironic as you were observing, Ms. Ocom, the chances that Mr. Hodges kept getting because he'd catch charges and then be back out on the street. I suspect that Mr. Hodges is also a young man who had very few chances that some of us have enjoyed. I don't know his background, and we didn't get into it, and that's his business. But in my experience, when we've got people with juvenile histories like you described, they're young men, and they're usually boys and not girls who have had no chances. They were born into a family where maybe there was no dad, or dad was abusive or was in and out of jail. And mom has struggles, and friends and family members are shot and killed around them all the time. Again, doesn't excuse, doesn't justify or anything like that. But I've got a sneaking suspicion that the types of chances that Mr. Hodges did get, because the juvenile system was appropriately lenient and maybe the adult system was too lenient with Mr. Hodges, are byproducts of Mr. Hodges not having had a lot of chances that really we'd hope everyone gets as they are growing up from 0 to 16. There's really not a happy aspect to any of this, other than Zaire seems like a fine young man and is heading off to high school thanks to his mom and extended family. And my hope is that he can walk in the footsteps of his father, but on beyond the age of his father when he was struck down, and get to be a father and a husband or whatever his life holds for him, and continue to make his mother proud. I know, Zaire, that your father is proud of you right now, of what you've become and where you're going, and keep that in mind. Mr. Hodges, I'm going to sentence you on count 1 to life. not life without parole. I'm not finding any of the aggravating circumstances, nor did the state argue for them. Counts 2, 3, and 4 are vacated by operation of law. On count 5, I'm sentencing you to 20 years to serve. Those 20 years will run consecutive to count 1. Count 6 is 20 years to serve. That will run concurrently with count 5. Count 7 merges into count 1, and count 8 will be 5 years consecutive to count 5 for a total sentence of life plus 25 years. You'll get credit for all the time that you've already served. I am not an expert in pardons and paroles, but I suspect your parole eligibility is going to be pretty far out, because the 20 years for the armed robbery, I don't believe are parole eligible either. That is a long sentence, but you killed someone and you took away a budding father and significant other and son, et cetera. And there ought to be a pretty significant penalty in connection with that. I need to share with you some appellate rights. You have the right to pursue a motion for new trial. That's when a lawyer who will be appointed to represent you will argue to me that either I made some mistakes or your lawyers were in some way deficient in their performance. So you're going to get a new lawyer, not with the public defender's office. And that lawyer will look over the transcript of this trial and decide what kind of arguments he or she wants to make. If I grant your motion for new trial, it means what it says. We start all over with, all right, let's pick a jury, and we do the trial all over again. If I deny that motion for new trial, you will still have a direct appeal to the Supreme Court of Georgia, where that same lawyer will be able to argue whatever he or she brought up with the motion for new trial, but to the Supreme Court. You have 30 days from the entry of your sentence, your final disposition, which will be tomorrow, to have these lawyers file either a notice of appeal. In other words, I don't want to do that motion for new trial. I want to get straight to the Supreme Court, or a placeholder motion for new trial. And they know what to file. It's just bare bones motion. And that will preserve your right to either appeal to the Supreme Court or have that motion for new trial. And you will continue to be eligible for free legal representation all the way through that appeal to the Supreme Court. Do you understand what I just told you? Your lawyers will talk to you about that, and you're going to give them direction. File that motion for new trial or file that notice of appeal, or don't do anything. One of those three. If it's one of the first two, direct appeal or motion for new trial, that'll stop the clock, and then we'll work on getting you a new and different lawyer who's not with the public defender's office. At the end of all those appeals, whether you pursue them or not, you have 4 years from either tomorrow, when I enter your sentence, or 4 years from when your appeals are complete to the Supreme Court to file what's called a habeas challenge. It's a civil suit. You don't have the right to an attorney for that, so you'd have to hire one or you'd have to do it yourself. And that's just an additional level of challenge that you can bring to your conviction and or your sentence. You don't need to worry about habeas until you're done with your direct appeals. And again, your lawyers can talk to you about that. They would not be involved in any of that habeas challenge. That would occur after your direct appeal, and you'd only have a lawyer helping you if you could afford one. Do you understand that last little piece I shared with you? Okay. Ms. Feely, Ms. Primovic, will one of you confer with Mr. Hodges about his thoughts about how he wants to or to pursue or not pursue his appellate rights?
I will.
Thank you. And if he wants either a placeholder motion for new trial filed or a notice of appeal, one of the two of you will take care of getting that in.
Absolutely.
As you always do. Thank you. Ms. Ocom, anything else we need to cover before we adjourn?
No, Judge.
Ms. Primovic.
No, you're on.
All right. Well, I want to thank the lawyers again for their hard work on this case. It was well tried by both sides. And we've reached a point now where hopefully Mr. Barry Buchanan's family can move on to whatever's next. It's been a long, long wait in so many ways. And I'm sorry that after that 2019 indictment, it still took 3 years to get into court. The pandemic did not help, not your problem, but it also slowed things down. Good luck with everything. Thank you all. Thank you, deputies.